Okay, take a seat. Good morning. This is the New York City Board of Standards and Appeals public hearing for September 9, 2014. We'll begin with a special order calendar. New cases, item number 1, 30201BC, 2519 Preston Avenue, the Bronx.
Good morning, Madam Chair. Welcome to your new position, and good morning, other members of the board. My name is Deirdre Carson. I'm an attorney at Greenberg Traurig. We represent Fordham Associates, which is before you today on an application for an extension of time to obtain a certificate of occupancy for an existing parking lot on Preston Avenue in the Bronx. This lot serves and has served since 1948 as accessory parking to what formerly was the Alexander's building, located at what is arguably the most important intersection in the Bronx, Fordham Road and Grand Concourse. As you probably know, Alexander's went into bankruptcy many years ago, and our client purchased the building, rehabilitated it, turning it into a successful and varied retail facility at the base with office uses above. Today, there are 140,000 square feet of office use in the former Alexander's building, all of it tenanted or soon to be tenanted by governmental entities such as CUNY, ACS, and Social Security. And some of these tenants have specific provisions in their leases requiring the provision of accessory parking in the lot that's the subject of this application. We understand from yesterday's session that you inquired about the efforts made to obtain the CO and the reason for the failure to complete within the term of the grant that was given at the time of the last renewal. To be blunt about it, there was a failure of communication and a change in personnel that resulted in a loss of the records that pertained to the approvals. And the architect failed to follow up with us until almost the date of the expiration of the grant. And it was only at that time, only about 2 weeks before the last grant was to expire, that they contacted us, and we became aware that they did not have and had misplaced the materials relating to the approvals. And at that point, everybody geared up and began moving very quickly. But at this point, all that we need in order to get the C of O is to have the extension of time. Everything else has been completed at the Department of Buildings, and this is all that is required for the department to sign off. We also took note of the fact that there were some questions raised about the conditions. We're not sure that, I'm not sure that jurisdictionally we can amend the term of the original grant within the scope of this extension of time, but my client did say that they would certainly be willing to repair the concrete base into which the fence is anchored, and that they would paint the fence black. It's the park across the street has a black wrought iron fence. It's not actually in very good condition. There's a lot of rust on it, but that's what the intent is, so we would paint our fence to match that condition.
I have a question about that. What do you mean jurisdictionally there isn't?
I don't know the answer to the question, but the only application that's before the board today is an extension of time to complete. And I think that you're proposing to add an additional condition to the term of the renewal, so that is not technically jurisdictionally on this calendar.
Correct.
It's just a technical.
But just a comment about that. I mean, I don't know if you've been to the site. Have you been to the site?
I've only seen it in photographs.
Okay, so if you just go on Google, you can see that it's in very rough shape. The fence is terrible looking, and that there are people who congregate around that area. And if this is, as you say, the most important intersection, Fordham Road and Grand Concourse, and your client is actually a major property owner, it's certainly within their means to replace the fence and to be better neighbors about it, because it is a permanent state and it's opposite a public park that has actually a very nice fence. So jurisdictionally or not, we're talking about continuing to operate something that may not be in the best interest of the community if it is allowed to decay like that. And just kind of general repairs isn't really functioning as a good neighbor.
Well, you know, we looked at the Google photographs, which were updated last year, and they didn't look that bad, but I haven't been there physically. As I said, the client is willing to make the repairs to the concrete foundation for the fence, but it's a fairly large fence and a fairly expensive proposition, and I'm not sure that replacing it with the fence across the street is not in great condition. There's a lot of rust apparent in the photographs, anyway, that I've seen. So I don't know that, you know, copying what's across the street is...
Well, it's a cast iron fence across the street.
It is, but it's in poor condition.
Well, you would be putting in a new cast iron fence, not a...
That's a huge expense for an accessory lot that's 67 cars. It's, you know, provided for government office workers.
Can you speak to your client about there instead of deciding for him right
Well,
there?
we have spoken to them. We came today stating that we would make the repair to the concrete and we would paint the fence. We certainly, if there's any sections of the fence that are not stable, we'd be happy to make sure that they're stable. But he's not anxious to incur a huge expense like that.
Could I ask what the timeline will be for these repairs?
I'd assume that they could be done within a month or two.
The reason why I ask is because while jurisdictionally we're not sure whether this is the proper question at this time, when this case came before us for an extension of term before, I know that I had been to the site and I had registered concern about the condition of the site back then, and we were assured at the time that the site would be spruced up. And so now that it's coming to us as an extension of term, it's not really a new issue that we're putting before you. We're really following up on an issue that probably should have been addressed the first time around. And so that's why I would like to know if there is an exact time frame for the repair, because I would hate to see this come up for another extension of term and then we're still back at square one wondering when this will be done.
As I recall, the issues that were raised the last time this was up for renewal of the term had to do with graffiti in the site and some, there was...
Graffiti, there was striping issues, there were
Yes.
issues with broken pavement, there were issues that basically pointed to the fact that the site had fallen into disrepair.
But I believe that all of those things were taken care of. The graffiti was taken care of, the restriping was done.
Right, but the general comment at the time, and I recall it, was that the site was looking kind of shabby. And the site is still looking kind of shabby. And it seems to me that one would want to, if you had a first-rate retail building across the street, that you would take pride in the rest of your property and want to make this property be as much of a flagship as your retail building is.
I'll speak to the client.
Thank you.
I would also have to echo, I went by the site the day before yesterday, and I understand that repair might be needed, but I think we kind of have to go a little step further. It's not in great condition, and I'm not sure that a repair, in the sense of maybe just simply patching, is going to really do the job here. So perhaps when you go back to your client, they could give us some sort of representation of what it's going to actually look like and what they're going to be doing. The fence itself, it's not in great condition, and just painting it may not, you know, there are gaps and it's kind of, it needs work. So I understand that replacing the fence might be an expense that your client may have a difficulty in achieving, but I think it's got to be something between replace and just repair. It needs some work. Okay. So if we could see perhaps a representation of what the plan is.
Okay. Thank you. Are there any speakers on this item? Okay, so when, let's see, can you come back to discuss this in about 2 weeks? Does that work, the 23rd?
Yeah.
Okay.
Sure.
Thank you. So what's the date, I'm sorry?
September 23rd.
September. And a submission date?
Is that right?
Give them a submission date?
A submission date. Sorry. Matt, come. So that means the submission date would be the...
I don't believe that we can guarantee that we'll have something to render for your review in a week.
Okay, so then...
Then we would have to put this over a month in order to give us enough time.
Okay, so submission on the... So then, sorry, October 8th then? Or October 1st? October 1st then? And the submission date on the 24th?
Can you submit by the 24th?
I have to speak to the client and the architect.
So how about we make it the 8th and a submission date on the 1st? How about that?
That's
Okay.
Thank you very much.
Sure.
Item number 2, 31806BZ, 4905 Astoria Boulevard, Queens. Mr. Palatnik. Leave the door open, please, in the text, so people, if they're outside to speak, can hear. Really? Okay. We may have to have them wait downstairs. This one now?
Start.
Good morning, Madam Chair. Welcome to your new position, and congratulations to your colleague for her recent celebration. We attended your review session yesterday, and I know you're familiar with the site at 4905 Astoria Boulevard, the Sunoco gas station, which is admittedly not as an important a corner as the last application, but was, until the community board meeting, which occurred, I believe, about a year ago, I was at. It's taken some time to get through this point in time. Was not run or operated in the best manner that possibly could have. The property is owned by Sun Company R&M, which is the parent company of Sunoco, which is obviously the gas station we're all familiar with. And for many years, Sunoco had an operator in place, a dealer, that didn't live up to the obligations of their contracts with Sunoco, and certainly didn't live up to the obligations of their previous BSA resolutions. It wasn't maintained the right way, the fencing was in disrepair, curb cuts were in disrepair, there was allegations of insidious activity occurring at the rear of the property next to a neighbor's home. When I went to the community board a year ago, Sun Company was made aware of that, and the photos that you see in front of you is the result of the actions that Sunoco has taken during the course of the past year to fix most, if not all, of the problems that were cited in the community board's resolution. Of course, we're here to extend the term. The property is in an R4 zoning district, and it's here under a variance that was first enacted in 1956. So it has a long history of this location. As you can see from the photographs that I see you're perusing, fence has been constructed. There's a new fence in place, not repaired, not patched, brand new. There's been curb cuts have been reduced in size to 30 feet, which is the lawful size that they should have been at. And that work has been done. And all signage that had illegal advertising signage affixed to it before has been removed. There's
Sorry,
also
which photograph is that one?
that I don't know if we've given you photos for, but we can certainly give you photos of that. I apologize if that's not in there. No, that's not in there, but we'll give you photographs of that. But it's all been attended to. And we've done everything that we can to bring it up to speed. We heard the comments yesterday that there is an indication that we'd like to see some more landscaping installed. I believe it was Commissioner Oliver Brown that raised the issue. And we'd be happy to do that if you give us some direction as to where you would like to see that landscaping installed. And I believe one more thing before I'll be quiet. Two more things, actually. I believe there's also a question about the fines on the property. Those of all, they will be paid shortly, but the violations, of course, can't be cleared until we get the okay from your board, and then we can go and resolve all of the violations.
Are all of the violations concerning the board, or do you have other violations?
I think most, I perused them, I think most are relating to the board action. We'll give you in the next submission any ones that are not, and an indication of why those have not been addressed, if there are any.
And you had some open jobs as well on?
Yes,
on the
those will be
property?
cleaned up when we go back and they do the filings. They'll all be cleaned up.
And just, so this the photograph is showing the fencing around the entrance to the restrooms? Is that hard to tell? Oh, or
No, the fence
that's
is showing the
the
fencing along the perimeter of the property.
And what about the one around the restroom area?
I don't know if that's still up or if that's been taken down. I can find out for you.
So that was something that was supposed to be installed, right? A fence so that you wouldn't, so the neighbor wouldn't be
You wouldn't
able
have to see
that.
into the
Yeah.
restroom. Well, I'll find
Right.
out about that, and we'll report back to you.
And then, one of the other questions was if you could get some information about whether the site with respect to the underground storage tanks is a tight site, that there hasn't been any leakage. That's something that's probably something that has to be filed regularly by the...
Yes, I'll talk to the engineer about that. Nothing's been brought to my attention that there's any problems with leaks, but I'll find out for you and we'll report back.
And then there was also the requirement to install a sign on 49th Street indicating the right-hand turn. Is that?
Indicating no right-hand turn.
Yeah, no
Right.
right-hand turn.
I'll take a look at that. I wasn't aware of that.
Okay. That's one of the requirements from the prior approval. Okay. And then, were you okay with the signage calculations?
I think Commissioner Ali Brown had requested that the signage be broken out by frontage.
Exactly.
So
Well,
if you could do that.
We'll have that done for you.
And then you need to amend your statement of findings to reflect these changes to the site
We'd be happy to do
and attach all the images that are relevant.
Of course, yes. We just gave it to you now just for your review, but we'll attach
Okay.
that.
The other images too that are missing from that, okay.
Yes.
Great. Oh, and then with respect to the metal storage container, what is being stored in there?
It's always, you see them around the city, I'm sure, in your own travels. It's a problem for them. They usually store, the auto repair shops, as this station is, they usually keep tires in there or other durable goods that they use in the shop that they just don't have room for to store in the shop. We'd like permission to maintain that, even if it's for a temporary basis, just to enable them to have the storage.
Well, but if it were only temporary, what would they be doing after that as more?
Well, I mean,
solution?
indicated in the resolution as a temporary, subject to your board's approval, but no permanent structure.
But since they obviously need the storage, what are the plans for a permanent structure?
We have no plans for a permanent structure. We'd
Okay,
like to
so-
maintain this as a
As a
quote-unquote
permanent-
temporary.
so it's a permanent
temporary
structure.
structure, yeah. Not, when I mean that, I mean not installed, no
Yeah.
foundation system
Yeah.
related to it and not connected to the earth.
Right, right. Because granted, it's not as prominent as corner Fordham Road and Grand Concourse, but it's a container. It's really a shipping container just sort of dropped down there, and it is kind of unsightly, and the whole idea was to improve the look of this site.
Would you like
Right.
it removed?
I personally would like a permanent structure constructed that would be the,
If the board would be amenable to that, we'd be happy to talk to the owner and see if they'd be able to do that. I'm sure they would be able to. I'm sure they'd rather have that than the temporary structure.
what, does anybody else have an opinion on that?
Well, either that or barring a new structure that for various reasons one might not be able to actually construct. I understand the temporary nature, but I think what happens with these temporary containers is that they begin to kind of look like temporary containers in a very short span of time. So if your client were to keep a container-like structure there, it would have to be kept in really good repair, painted, kept graffiti-free, and really look like something that could be permanent.
Why don't I go back to the engineer and come up with a couple of design options maybe and show you aesthetically what they could do with it maybe.
Yeah, I would prefer to see it as a permanent structure because there's no way to make a container not look like a container. So, I think eventually it would have to be permanent. Yeah.
All right, we'll discuss that with the client and I'll report back. And Commissioner Ali Brown, the
I
landscaping.
was the one who had the landscaping
Yes.
comment. Right now you have grass, and the grass is not well seeded in places, so even your pictures show that, of course, where it isn't well seeded, there will be litter, as well as the fact that once the season turns, your grass will no longer be green. So if you can put some sort of a nice hedge up there, that would make a very nice border. That would soften the transition between
On
the
which
gas
side are you
station.
speaking of?
Between the gas station and the residential right next door, so behind the building.
So maybe if we put some evergreens or something along
That
the
would
rear
be,
property
that would be
line.
great. And I think that will stop people from dropping litter in that area and will also stay for all 4 seasons.
I understand.
Do you have trucks parked on that site?
No, we don't have trucks. We were surprised to get the comment yesterday. The site is a very small site, as you know, and it's under the full control right now of Sunoco. If there were trucks out there, it's definitely not under our authorization. We were surprised to hear it. I've been out to the site, I haven't seen trucks. But if you were there and you saw them.
Yeah, I mean, maybe it's just a coincidence, but in your photo, you show two sort of white panel trucks, and when I went to the site, I saw two white panel trucks that resembled these, and it's been, you know, several months since the photos and the time I did a site
Yeah, no,
visit.
so it would sound like they link up. Let me speak to the
Said,
owners.
yeah.
Sunoco, and we'll find out.
Great.
But either way, they're not supposed to be there, so they'll be gone.
Okay, is that it from
That's
you?
our presentation.
Are there any comments on this, any speakers on this matter? Okay, so, how much time do you need?
If we could submit, if you could allow me 3 weeks to make a submission,
So a submission on the 8th then?
that'd be great.
Okay. And then hearing on the 15th? No, not the 15th, that's that. Sorry, that's your hearing, this one. Oh, okay. On the 21st then? Does that make sense? Or
That's
is it
great.
weekend or not? Maybe make it the 28th.
28th.
Maybe the 28th, sorry.
Okay.
Okay, so submit the 15th.
Submit the 8th and the 28th.
Submit the 8th, right, submit the 8th,
And then the 28th.
right.
Okay. Thank you for your time.
Hearing date is October 28th.
Yeah.
Item number 3, 19312BZ, 384 Lafayette Street, Manhattan, Rockford and Walkthrough.
Todd Dale for the applicant. Good morning and welcome. From review session, there were two questions that were raised. First, regarding the signage. The signage analysis form isn't conducive to showing, but on the plans, just to clarify, all new signage is proposed on Lafayette, and it's 45 square feet, and it's just the extension along Lafayette where the new entrance will be proposed. So it's 45 additional square feet. And it is marked on the elevation plan. The total square footage is noted on the signage analysis. I think there was also a question regarding the hours. No changes in the operation are proposed, and that includes the hours.
Note there's, the community board hasn't submitted their response yet.
I'm not sure what happened. You know, over the summer, some community boards do take a break. We did provide notification. We provided proof of notification of the board. In August, we had reached out to the community board, left a message, asked them if they wanted to weigh in. This community board has waived PCE application. In this instance, since it's a 1,200 square foot on the first floor change, I expect that's the case. We'll reach out to them again, but you know, we did provide notice and we provided proof of that notification of the board.
Okay, that you submitted to us, okay, great. Okay, any comments from anybody? Are there any speakers on this item? Okay, so we could, let's see, so is there anything that needs to be submitted with respect to the signage? No.
If all you're doing is adding the 45 square feet and everything else stayed the same as the last grant, basically.
Right, and we also submitted the certificate of no effect from Landmarks in the notice of comments response.
Okay. Okay, so we don't need any further submissions. Okay, so then we can set a hearing, a decision date, and close the hearing and set a decision date for the 23rd. Is that okay?
10:23.
No, 9:23.
9:23? Okay.
Okay,
9:23 decision.
Great.
Motion to close?
so move. Oh, motion to close? Yeah.
Motion to close. Chair Perlmutter?
Yes.
Vice Chair Hinkson?
Aye.
Commissioner Montanez? Absent. Commissioner Otley Brown?
Aye.
Okay.
Thank you.
Appeals calendar. Item number 4, 14514A, 13616 Carlton Place, Queens.
Good morning, applicant Lam.
I don't think we were waiting for anything else on this.
Okay.
He revised his facts and findings, and he showed us photos of the street and the curb cuts, and he showed us how the car actually gets to the rear of the property. I had no further issues.
And no issues with that either? Okay. Are there any speakers on this item? Okay, then we can set a decision date for September 23rd. Okay,
Okay, thank you so much.
and close the hearing.
Chair Promoter,
Aye.
Vice Chair Nixon,
Aye.
Commissioner Otley Brown.
Aye.
Thank you.
Thank you.
New cases, item number 5, 27813A, 121 Barrack Street, Manhattan. That's why I said leave the doors open, ladies. Could you open the door for me, please? Thank you. Stewart, Building Department, please. Thank you.
Good morning. I'm Stuart Beckerman from the Law Office of Slater and Beckerman. Welcome, Chair, Madam Chair. I'm here for, I'm representing 121 Barrack Street Corporation, which is the owner of the subject premises, and we're seeking a reversal of the Buildings Department determination that the approximately 5,625 square foot indirectly illuminated advertising sign located on the south wall of the premises does not conform to Section 4255 of the zoning resolution because, according to the Buildings Department, the sign is within 200 feet from and within view of an arterial highway. In this case, what the Buildings Department is identifying as an approach to the Holland Tunnel. I was at review session yesterday, and the boards believes that our argument that there are no approaches, I think that the phrase was hard to understand. And the reason why I believe the board found it hard to understand is because that would mean, our interpretation would mean that the zoning resolution, which specifically lists Holland Tunnel and approaches as an arterial highway, is incorrect. And I understand we're asking the board to reverse long-standing Buildings Department policy, but the law supports our argument, and our papers on September 26, 2013, our brief, and our response to comments on June 18th of this year, I believe, provide some support for that argument. And in our next written submission, we're going to provide further legal support and more, I think, helpful documentation. So in a moment, I'll briefly summarize our argument. But again, I just want you to understand that our next submission, I think, will more fully educate and explain this issue to the board. So the sign was installed in 1998 pursuant to a lawful Buildings Department permit. At that time, the zoning was M16, and at that time, in an M16 district, there were no restrictions on surface area, height, or illumination. In 2001, the law was amended so that now there were some restrictions that did not previously exist. And then subsequently and more recently, the site was located within an extension of the Special Hudson Square District, at which point some more restrictions were imposed. And so the sign remains, in our view, a non-conforming sign. We acknowledge that, at least in regard to those non-arterial highway regulations. So briefly, our main argument is as follows. There were no approaches to the Holland Tunnel within the meaning of Section 4255 of the zoning resolution. And we start with the definition of arterial highway in Section 4255, which in relevant part says that an arterial highways are, quote, all highways that are shown on the master plan of arterial highways and major streets as principal routes, parkways, or toll crossings. And so there are two pieces to this definition, and so there are two separate requirements, and that have been designated by the City Planning Commission as arterial highways. So this morning I'm going to focus more on that first part, but we're going to provide some documentation that will even challenge the second part, but I'm not going to get into that today, because I think it's enough that we can't even satisfy the first part. For the approaches to be considered part of the arterial highways defined by Section 4255, the approaches themselves must be shown on the master plan, which was adopted on April 11, 1945. The Holland Tunnel actually predates 1945, so it was existing. And by the way, at that time, what the Buildings Department is now calling approaches didn't even exist. Instead, there was a plaza, what was called an entrance plaza, and there was actually a toll there at that moment. That no longer exists. The tolls have since been relocated. There is no more toll on the New York side of the tunnel. So when you look at the master plan, only the tunnel itself is shown on the master plan. And I don't know if you have the master plan in front of you. We have the large copy somewhere, but we can probably submit that if we haven't submitted that to you.
Actually, it would be helpful. The Department of Buildings submitted a small blow-up of it, but if you could, yes, submit the large
Sure,
one, that'd be
we will do that.
Mhm.
So what this means is, the master plan actually shows the Holland Tunnel as one of, quote, toll crossings under authorities, unquote. So what this means is that the boundaries of the Holland Tunnel as an arterial highway are determined by the Port Authority, which has exclusive jurisdiction over the tunnel. And the Holland Tunnel and the Port Authority, not the Buildings Department, has the sole jurisdiction to define the location of approaches over the vehicular crossings between New York and New Jersey. And we provide support for this. I don't need to go through each and every citation, but the unconsolidated laws in New York, which include the enabling statute, specifically says that the Port Authority has sole jurisdiction over vehicular crossings between the two states, and the definition of vehicular crossing says shall include the bridges and tunnels and the plazas, approaches and highway connections thereto within the jurisdiction of the Port Authority. It also says that the determination of locations of approaches must be exact. So again, you've got to refer to what the Port Authority has determined to be an approach in the absence of any other statutory provision, and there is no other statutory provision except the reference to what is on the city map, which is based on a toll crossing under the authority of the Port Authority. And so actually, right, and what it says here is, this is also a direct quote from the unconsolidated laws, the enabling statute, that the determinations of the exact location, and I'll paraphrase, the exact location of tunnels and approaches shall be indicated upon said map. So, and in this case, the map does not show the approaches. And I think it's worth noting that when you look at other toll crossings under the jurisdiction of the Port Authority, namely the George Washington Bridge and the Lincoln Tunnel, the enabling statute actually defines the location of each of the approaches. That is not done here.
Sorry, can you just go back on that
Sure.
one? Because on those other sites, the enabling statute only identifies sort of an area. It
Right.
says sort of 31st to 34th Street or something like that, right? And west of 9th Avenue, that's not an exact location.
Well, it's more exact than what is provided for with regard to the Holland Tunnel, which is nothing.
But if you were to rely on that, let's say you had a sign that was within view of the sort of description in that enabling statute, then you would be arguing that it's not specific enough, right? Because it can't possibly be that all of those streets between west of 9th Avenue are approaches, right?
Right, I understand,
So that wouldn't
but
guide you, really.
well, we'll address this in our written submission. I hear what you're saying, but I think in that case, while it may not be exact with regard to, which street and which, the extent on the street where it's located, at least the enabling statute does in fact identify some kind of an area, and we have found nothing on the Holland Tunnel in that regard. And as I pointed out, there have been changes over the years, so there have been opportunities to enact laws to reflect these changes, and that has not been done.
Can I just ask a question? Is the Holland Tunnel situation the only situation in which the Port Authority has authority over its access to either a tunnel or a bridge? Is this the only instance in which there is no description of access? Or are there
I don't know
others?
the answer to that, but I'm not sure.
In other words, is this just an anomaly, or is this something that one could look at and say, well, it's kind of loosey-goosey, or...
I think, I appreciate the question. I don't think it's relevant. We'll be happy to answer it. And I say it's not relevant because we start with what the statute says. And I can't really speak to other crossings. I can only tell you that I looked at those 2 other crossings, and we see that the enabling statute does identify locations. But we'll get into that, actually.
I think it's relevant to show whether or not there's sort of a pattern in how these things have been decided, and I would like to know what that pattern is to be able to figure out how your situation fits into that.
I appreciate it. I'll give you just a brief preview of our research. But what we have found is when N approaches was added, it was just sort of added on motion at city planning, and it was just sort of attached to every single toll crossing, I believe, on the list. And prior to that, it was not in the legislation, in the New York City zoning resolution. So we will address that, and we're going to do more research on that area. So we'll be happy to provide you with that information.
Sorry, were you saying, so another part of the argument is that it sounds like that when it says Holland Tunnel and approaches, the and approaches is a mistake, right?
I think it was, I wouldn't say it was a mistake. I don't know. I can't really say it was a mistake, but we will address that.
Okay, because one of the reasons that Commissioner Hinkson's question for me is relevant is, are there other arterials where there's an approach that's described and then there are no approaches? So was that sort of just boilerplate city planning language whenever there was a tunnel and a bridge?
Right.
Or is it more specific because there's always an approach? And that goes then to the question is, so okay, it's not shown on the map. It wasn't mentioned in the legislation. Nevertheless, you do need to get to the tunnel. And at some place or other, there's something that's got to be an approach. For instance, if it was a toll plaza originally and now it's just that plaza area, wouldn't that have been the approach? And if you're willing to concede that that might have been the approach that city planning had in mind, then what's your distance from that part of the plaza, at the very least? The other thing, in your papers, did you include the zoning resolution that was relevant to the time period of the permit?
You mean in 1998?
Yeah.
Well, I'm not sure what you're asking.
Well, because you said that there were no regulations that applied to the size of the sign.
Oh, right. Okay. No.
Yeah.
Oh, yeah.
Yeah.
I don't know if we did, but it's been a while. So.
Okay.
And I wasn't directly involved at that time, but I will definitely. We will provide that with you. Provide that for you. Absolutely.
Okay. Is that all that you want to say?
That's it for now.
So then I just wanted to ask and this was a question that was really posed to the Department of Buildings, but maybe that you could take it from the other side of the story, is Rule 49, which was enacted in 2005, talks about the definition of approaches.
Right.
And so maybe you could also be taking a look at what the Buildings Department's historical behavior was with respect to approaches. Sure. And then the other one is about the 360 view.
Right.
What kind of cases have there been where other than a 360 view has been applied?
I'll just point out that those issues are really not relevant if the board were to adopt our initial argument. That would be sort of an alternative argument since we're saying that there are no approaches.
Right,
but
let's just say we've got the plaza at the very least as an approach.
I mean, the Buildings Department does not, when they promulgate rules, they don't pass law. And there's, they're simply stating it's supposed to provide some guidance, I think, to the public and to the agency in the implementation and the enforcement of these laws. So they cannot overrule what the law provides. But we will address those questions.
Mm-hmm. Okay, thank you. Okay, yeah, so Ms. Ferrantia, you want to?
Thank you.
Department of Buildings.
Good morning, Lisa Orantia for the Buildings Department. This appeal challenges the revocation of a 1998 permit. It's not non-conforming because in 1998 the sign was prohibited by Section 4253, and that was a provision that had been in effect since February of 1980. Now the sign is unlawful with respect to at least 3 arterial highway approaches. The sign is prohibited because it's within 200 feet and within view of an approach at Broome and Barrack Streets. It's also prohibited with respect to an approach that is within 200 feet and within view, where the road goes below ground to the west of the building. That's between Hudson and Varick Streets. And third, even if the board were to find that the sign is not within 200 feet and within view of those approaches, it would exceed the size limitation of 4253 because the surface area is larger than the linear distance to the approach that's located at Watts and Varick Streets, and that's 398 feet away. So the sign would be limited to 398 square feet.
Sorry, just a question there. Are you saying that that was the rule that existed in 1998 when the original permit was issued?
That's right. 4253 is the applicable section, and that was a provision that had been in effect since 1980.
With the size limitation?
Correct. Now, I know the board had some questions about the Rule 49 definition of approaches. That is the definition that the department uses to determine the precise location of an approach. An approach is the term that you see in the appendix where city planning has designated arterial highways. In this case, it's the Holland Tunnel and approaches. It's correct for the department to use the rule for a permit that predates the rule because the rule's definition codifies an interpretation of the meaning of the term approaches, and this is always the way the department had understood that term. There's no record of a more limited definition than the rules. The department has never recognized a grandfathering of a sign that existed prior to the date the rule was promulgated. In other words, there's no concept that the sign was lawful, that a sign could be lawful because it predated the rule. And even under a common sense layperson's understanding, the approach would be, an approach would be a portion of a roadway that connects a tunnel to a local street network and functions to service a tunnel. And we believe that at all 3 points that the department has identified, even a broader understanding of the term approach would be satisfied here. We also believe that it would be more difficult to create a standard that's more limited than what's described in the rule. It cannot be a point, of course, when you are already in the tunnel. An approach has to be a point where the roadway nears the tunnel and leaves the local street network. And again, that's what the rule tells us. And the board has already recognized Rule 49's definition applies to permits that were issued prior to the promulgation of the rule. And the rule took effect in September of 2005. So we have found 6 cases that we believe are relevant to the present case. And I could provide more detail in a subsequent letter to the board, but we have 462 11th Avenue, Manhattan. This was a 2000 permit, year 2000. And the board found that photos of the signs taken from approaches are clearly visible from that point on the approach and therefore within view, within the meaning of the statute. 393 Canal Street, Manhattan, this was a 2001 permit. The board found that a sign facing an exit roadway from the Holland Tunnel emerging south of Canal Street near Hudson Street also met the rule's definition of an approach. Photos of the sign from the approach show that the sign is clearly visible and therefore it's within view, within the meaning of the statute. 13 Lake Street, Manhattan, these were 1998 and 2000 permits. A sign facing Varick Street south of Canal, east of the exit roadway of the Holland Tunnel, also met the Rule 49 definition of approach. Again, the sign could be viewed from points on the approach and was within view. 442 West 36th Street, Manhattan, this was a 2001 permit. It was a sign near an exit roadway for the Lincoln Tunnel, again met Rule 49 criteria. 538 10th Avenue, Manhattan. This was a case that was denied, Article 78 was denied. The board upheld the department. It was a year 2000 painted sign seeking legalization. This case is significant because the board agreed with the department that the proper standing for determining the meaning of the term within view is the 360-degree standard. And that means that the sign can be viewed from a specific point on the arterial in any direction by a driver or a passenger. And then lastly, I wanted to mention 111 Barrett Street, Manhattan. This is a sign that's located between Broome and Dominic Street. In that case, it was undisputed that the sign faced an approach. The issue in that appeal was one of discontinuance, and it wouldn't have even been relevant if all the parties in the PSA did not agree and accept that the sign was not currently allowed because of its proximity and visibility from an approach to the Holland Tunnel. So I'd like to submit these cases to the board.
It would be helpful if the cases included some visual description of where the signs are,
Right.
and so we can understand.
I have maps that pinpoint the location of each. And then finally, even if the sign were to be considered non-conforming by the board, the department has submitted evidence of discontinuance. We've submitted photos of a blank wall, at least from July 2011 to August 2013, and even if there were a non-conforming sign here, it was discontinued and needs to terminate under section 5261.
Well, with respect to that, if the owner removed the sign simply to comply with Department of Buildings requirements that the sign be removed, it was simply obeying the law, then why would that be considered a discontinuance under the intent of the zoning resolution?
Well, we could consider that. I haven't seen that information from the owner.
Okay. Okay. Any other questions? No? Okay. Thank you. Okay. So how much time do you need to make your submission?
4 weeks.
4 weeks. Okay. So what are we? So a submission on the 7th, the 21st would work for submission date? Maybe the 14th? Okay.
October
Okay,
14th.
submission on the 14th, and then a new hearing, another revised, whatever, updated hearing on the 28th. Is that good?
Chair, submission for DOB.
Oh, sorry, I'm sorry. And then, so the 14th, and then Department of Mr. Rantia is 2 weeks after that, good for you? Okay, so then the 28th submission, is that okay?
And then can we have
And then you-
do a reply?
Is a week enough? Or?
Sure.
Okay, so that brings us, this is off, what is this?
Is that election
Those
day?
are election day.
That's election day.
Well, we could do this, we can do the submission by election, you know, by that
Okay.
Wednesday maybe.
Okay, so the 12th then, right?
Okay.
And then a hearing on the 18th, is that enough time to read it? Okay, is it okay? 18th? Okay.
Okay.
November 18th.
What? Sorry.
Sorry, could we do, well, I think we can do that, but I think the hearing would be, I'm sorry, would be when?
Could be the 18th or the 25th of November.
So you want to do the following week? Okay, the week after the 25th.
So a submission for, okay, the week after the 25th?
Yeah,
Okay, so that would be the 9th then of December. Is
okay.
that okay?
So
that's
I
the
guess we can
hearing.
then move the dates for the submission.
Yes.
Why don't we move the, sorry. I think we're okay. Yeah, we're okay with that.
You're okay with submitting the response to the Department of Buildings on the 12th? Because you could also take it
Wanna
to
do
the 18th.
30th? We could do the 30th, I guess.
30th, is that okay? That gets us till the 9th? Yeah, that's okay.
30th, perfect.
So submission dates are 10/14, 10/28 for buildings, and the final submission
The 30th
of
of November.
November.
And the hearing date is the 7th.
December 9th.
The 9th, sorry.
Okay.
Okay.
Thank you very much.
Thank you.
Bye-bye.
I hope you got all that.
She did.
Okay.
She's got it together.
Zoning calendar, item number 6, decision item 29713BZ, 308 Cooper Street, Brooklyn.
Richard Lobel of Chelmsford PC for the applicant. Good morning.
Good morning. You asking for deferment?
Yes, the applicant obviously is confronting certain environmental issues on the site. To the extent that the board would grant us a further adjournment, we are conducting independent testing within the next 2 weeks, and we'll have a report prepared probably within a week or two after that. So we're actually moving fairly rapidly on our schedule. I understand the board's been gracious to this point, but if we may have a further adjournment, we appreciate it.
Yeah, that's okay. So how much time do you think it'll take before you get the reviews from, because we need to have the reviews from the agencies too, so.
Right. I have Jim Heineman from Equity Environmental, which is conducting the testing.
Hi, James Hyman, Equity Environmental Engineering. Welcome, Madam Chair. Good to see you all. As you may recall, our site is across Irving Avenue from Wolf Outport, which is a Superfund site. They were involved in refining thorium, and there are some radioactive issues on their site. There's been no indication that the radioactivity has spread off-site other than into the sewers in the streets is where they've traced it to. They've not traced it across the street onto our site. Nonetheless, DEP had expressed some concern, and their initial recommendation was basically to treat our site as a known radioactive site, which involves rather onerous costs in terms of how you conduct the investigation, what's involved. Our position is that although it is suspected, it's reasonable to suspect, it has not been demonstrated as a known site, and therefore we're doing currently, and what we'll be doing later this month, is a kind of initial screen to identify whether in fact there is radioactivity on the site. And if there is, then the assumption would be that it's due to the Superfund site across the street, in which case EPA would become involved under their current role managing the Superfund site. If it's not, then we would hope that DEP would concur with us that it does not need to be treated as a known radioactive site. We demonstrate that it's not, and therefore we can proceed with the more typical investigation and identification of any remediation we need. So that is the reason for the delay in the schedule. Getting back to the actual original question, we'll be doing the field testing later this month in about 2 weeks. The report will probably be another 2 weeks. So about 4 weeks from now, we expect to have our results to DEP, and then they would have to determine what they think, and then we're either back on the usual schedule, or we're if we do determine that the site is radioactive, then we have to revisit how this works in terms of the EPA management of the Superfund site.
Right. Just a question. This might take months, really, not 2 months. This might take 5 months, right? Is it something where we can either adjourn this very far in the future or just take it off the calendar? And is that something?
Yes,
yeah.
We could take it off the calendar.
I think instead of you having to come back every single time, it'd be just easier once you have the materials, submit them, and then we'll reschedule. Yeah.
Right. Okay, so we're going to take this off calendar?
Okay.
And we'll update the board after the next testing occurs, and hopefully we'll have some good news.
Okay, thank you very much. Continued hearing items, item number 7, 2-13BZ, 438 Targee Street, Staten Island, Mr. Duarte.
Good morning, Madam Chair, welcome aboard, commissioners and staff. I'm Alfonso Duarte for the petition. I believe at the last hearing, there were certain items that the board wanted to be elaborated on. One of them was the comparison of similar lots in the area. And I submitted under the case 4 properties that were similar, triangular in shape. You must bear in mind that our lot is only 2,060 square feet. The 4 properties that I did, if I may run through them very fastly, is 50 Irving Place. That has 3,300 square feet, and that was developed prior to 61. 51 Rough Street is 3,496 square feet. That was developed under the zoning, the present zoning, but that's larger than our property by at least 1,400 square feet. 56 Rough Street is 2,451. What the owner did, he took this lot and the 6 adjoining lots and made one zoning lot out of it. And that's how that lot got developed with this whole development. And 450 Taji Street, excuse me, which is right below our property and approximately the same size as our lot. But that lot was developed prior to 1961. And if they try to develop a vacant lot under today's parameters, I believe they would have the same hard time that we're having to meet the requirements.
Is that property built full to the lot lines and doesn't have any setbacks? You're saying that
the
they
one
built
at 450, the one below 450 Taji
Yeah,
Street?
right. In other words, you're saying that it wouldn't be affected the same
Right,
way
'cause
today, but what is there?
It was filed under and built under the parameters of this 1916 zoning resolution.
Right,
If
but
it
so
had-
is it built full to the lot lines?
I couldn't, I
Well, a site
requested,
visit
I
actually.
requested the microphone from the department. It was not available.
Right,
And whatever was available is not legible. So I really don't know what the parameters are with the lot line and the building.
right, but just a site visit or even going on Google Earth or something, you would be able to see, is the building fully built to the lot line? Just, you'd be able to see that looking at a map, right?
Well, I don't think it's right on the lot line. I think it's off the lot line, but I'm not sure. I
Okay,
can't tell
but-
without a survey.
Okay, so, well, yeah, you could tell without a survey. You could actually tell by just looking at it, whether the property at this site below is built to the edges, because the issue is that the zoning regulations currently prevent you from doing certain kinds of things, right?
The
They have
way they
setback
show it on the radius diagram, the building's at the lot line,
Okay,
okay?
okay. So it's great that you provided those things, but you need to tie that back into your argument. So you need to say that, for example, those other sites, each one at a time, this site is bigger than the site that we have, therefore there's more opportunity to make a return on their investment because they have an extra 1,000 square feet, for example.
Well, I put that in on my last revision.
Okay, okay. It's not so clear. You'll work with the staff person to work on improving the argument to make it very
Okay.
clear that this is distinguished from your site, and your site has much less floor area, for
Okay.
example, or the building that was built on that site was built pursuant to 16 zoning, and so that's the specific distinction between your site and that site, okay?
And I tried to get that information from the building department with the microphone, but I was unsuccessful as to what the floor areas are or whatever. That I couldn't do. Now, the other item, if I may go on, was the signs. Now, the proposed sign on the extension will meet the requirements of the C1 area. It's much less. The sign that's on the existing building, the food market, consists of an awning. An awning is restricted to 12 square feet, I believe, of sign. This really exceeds it. But if you add up all the sign areas, it meets the requirements of the C1 area for a flat sign. And I'm asking the board to consider approving the awning sign, basically because it's not in a strictly residential district or zone with residential buildings. Taji Street is a 2-lane highway, and there are commercial uses along the street already. So I'm asking the board to accept the awning sign that's there now with the excessive signage on it. Okay?
Do you know what the total then would be? The total square
The
footage?
signage would be what the C1 area allows,
Which would be?
and that would be 106.50 square feet. But if
Plus-
you add up all the signs that are on the awning
So
now.
that's your total for the awning sign plus?
No,
the
the
new
awning
portion?
sign.
Only the awning sign?
Only the awning sign.
And so then add that to...
And that meets, if that was a flat sign, it would meet the zone.
Understand. I just want to know what the total square footage of what you're proposing is for the entire site. So if you have 106.5 square feet on your awning, how much are you asking for? Well, how much is the C1?
The flat sign is roughly, I believe, around 60 square feet.
So that would bring it to 166 square feet of
About that,
signage?
yes.
That's what you're asking for?
Yes.
And in total, does that exceed the C1 regulations, or?
That would exceed, that exceeds the C1. In total, it would
Well,
exceed
if it's a separate retail store, I believe each unit will stand on their own, have to stand on their own feet.
It can, it can
So
do a
the retail portion, we are under the allowable signage area for the proposed retail side.
You're meeting the C1.
We're gonna be under it. We're gonna be under requirement. It's 3 times the frontage, and we're gonna be...
Frontage of the establishment, if you're gonna
Yeah,
go
of
like
the
that.
proposed establishment, retail.
Okay.
And they're going to be definitely 2 separate retail
I
establishments.
I believe so, but it could, the food market may be able to go in there.
Because
and then the sign-
then it would
right,
be
correct. I
over your
understand.
signage square footage,
I understand that.
right? So
Right.
we need to make sure that it's, if you're proposing
we're going
this, it's
along
actually
with
2 separate.
presumption that it will be a separate retail store. If it has to change, we'll come back to the board or get your comments. And I believe the last item, if you don't have any questions, further questions on that, was the financial. Okay, I have Ms. Marlene Sigmund here, who has prepared the revised financials. Okay?
Thank you.
Morning. I submitted the financials.
Oh, please state your name for the record.
Oh, yeah,
Sorry.
Marlene Sigmund, S-I-G-M-A-N.
You want to just go over what it is you submitted and what you argued?
Well, there were 2 main changes from the earlier submission. Number 1, the board had requested that I eliminate the illegal portion from the valuation of the existing property, which I did. And the second was because so much time had elapsed, I updated the comparables and incorporated the new comparables into the financial analyses, which were done precisely the same way the old ones were done, except with, as I said, omitting the addition from the depreciated value of the existing property, and also with some changes to some of the comparable numbers.
Commissioner A. Brown, did you have questions about this?
I actually think that you revised the financials as we had expressed we wanted them done. I think what we need at this point from you is just some narrative information that would tie your financials into your A case, and your A case being the size and the shape of the lot being what the factors that are prohibiting you from getting an acceptable return. So if you can tie that into why you chose to develop in this fashion, and to also rule out any other alternatives, then that would complete it. So for instance, if you could say the size and the shape of the lot compromises the lot by not allowing you to develop to your max, okay, in terms of FAR,
Right.
and also compromising the floor plate so that you would have a small floor plate that would allow you to get less than optimal income.
Right.
And also talk about the fact that you, being that you do have a legal non-conforming retail at this site, to continue to develop in retail, you would not want to then use extra square footage in a second floor, because that also would not lead to an acceptable return, because in this area there certainly is no market for second floor retail. So if you can kind of tie all of that in, your findings from your
So basically, you want me
financials.
to eliminate the possibility of a second floor retail, and why? And then just tie in the physical parameters of the space with why the financials don't work out.
Exactly.
So just to pick up on that, so you have 300 square feet that's being left on the table.
Right.
And that's because the apex of the triangle doesn't allow you to construct there, right? Because it's just not a usable area.
Correct.
So if you had a simple rectangular 2,000 square foot site, that's a pretty small site too. So you would also argue, look, that's a very small site to begin with and difficult to realize a return even with a variance, but difficult to realize a return, for example, with residential or with community facility, which was another one that you could have looked at, like for instance a medical office. It would have been,
Can I just
let me just finish that one thought. So if it was a rectangular site at 2,000 square feet, that would still be something difficult to achieve. But this is a triangular site where you're really restricted by the shape. It sort of necks it down, and then you've lost the apex of the triangle, that 300 square feet. So in addition to the hardship of having a small site, you have this site that prevents you from using all of your floor area, and the only place you could put that extra 300 square feet is on top. And in all of the scenario that you studied, a 300 square foot thing on top wouldn't be viable because, for example, in both a commercial and a community facility building, you'd have to have an elevator, and in any event, you'd need to have a staircase, and by the time you're done, you barely have anything up there, right? So if you could include that, what that does is connects the financial aspect of it directly to the unique physical condition, which is your triangle. Right? They need to be linked, okay?
Any questions?
No, I think I understand. I was just going to comment that the architect had done a community facility drawing for me, and we both agreed that it was so infeasible that it wasn't even worth.
Okay, so if as recommended, the narrative says it's so infeasible, kind of, and it's infeasible for these reasons.
Right,
so we didn't even, run the rest of the calculations. Okay.
How much time do you have?
Okay. Probably I'm going to be away for a couple of weeks. I would say a month.
A month. So could you submit on the, what is that? On the 14th of October?
We do one more week?
One more week, the 21st of October?
That's when we're going to have to file it, or?
That's the submission date, yeah.
We have to get information before.
No, this is her submitting her materials.
Oh,
And
submission date? No.
Yeah, you submitting your materials and her submitting her materials.
Okay, submission date is?
The 21st
Okay.
of October.
Okay.
Okay, and we could set the hearing date, is the 28th too soon, or we do it for the 18th? Otherwise, it's 21st, she submits.
Sorry, Madam Chair, speakers.
Oh, speakers, I'm so sorry. Okay, is there any speakers on this matter? Lucky, okay.
Thank you.
So the 18th, is that for the hearing date? So you submit on the 21st, and the 18th is the hearing date.
Okay.
November 18th?
First and the 18th.
Yeah.
Okay, thank you very much.
Item number 8, 26413BZ, 257 West 17th Street, Manhattan, Francis Angelino.
Good morning, Chair Perlmutter and Commissioners.
No. Sorry, just 1 second. 10/21, and the hearing date is 11/18. Yeah. Sorry. Okay.
Good morning, Commissioners. On July 15th, we had our initial hearing on this case, and after the hearing, as indicated at the hearing, we had testing on July 23rd of a new sound system, a directed sound system with controls and limiters at the site. I was present at that, along with the sound consultant for the opposition in this case, as well as their attorney and others, and our attorney. As a result of that, you're going to hear David Koch describe in detail of Criterion Acoustics the results of that test, which showed that there was no sound that penetrated into the apartments at the lowest floor. We will also testing, we brought in the brick CrossFit, brought in Wilson Eyrick, which is one of the country's premier vibration consultants, and they were present too at the July 23rd testing. We had an opportunity because we have to schedule these tests since we're going into a residential building to also drop some weights to give Wilson Eyrig some background. It wasn't a formal test, but it gave Wilson Eyrig some background as we aim towards a permanent solution to any vibrations that this club is causing. And as a result of that, and the intervening weeks in August, both Criterion and Wilson Eyrig have come up with a solution which basically re-engineers the special sound floor that was put into the club that we believe was not working properly. And they've engineered it and have a methodology for going forward, which will begin immediately to cure the problem. Our intention from the beginning, as we've stated, has been to make it a win-win situation for both the tenant tier, which is the club, which occupies a commercial space on the ground floor of a residential building which has 10 floors of residences above, which is in a separate condominium and has no privity except for the physical fact that they reside above a commercial condominium. So again, we were all directed towards a win-win situation. In addition, during this time, one of the owners of CrossFit has just in the process of opening a CrossFit gym in Chicago in a very analogous situation. It's a building which has retail actually below it and a high-rise of residential above it. And they've engineered a new floor and tested a new floor in a very similar way that they're going to re-engineer this floor at this location so that they have a direct experience, very recent, with implementing a floor that will not cause any vibrations. And as you will hear, that David Koch will describe in detail what they're going to do, and there's a certain amount of steps, including taking out building permits, hiring a construction company, doing the work, and re-engineering the floor. And they're committed, Rick is committed to doing this. So I'm going to have David Koch from Criterion, with your permission, describe the test that he did and the results of that test and the way forward to get a permanent solution to the flooring. Thank you. Introduce yourself.
Hi, how you doing? I'm David Koch from Criterion Acoustics, and I just wanted to bring everyone up to date on what we've done since the past BSA hearing and what we plan to do to rectify this situation. So on Wednesday, July 23rd, testing occurred primarily for commercial music with us, Acoustalog, their attorneys, our attorneys, etc., and the residents above. Primary focus of this testing was for code compliance for commercial music. The secondary concern was to get true vibration data in the apartments above. That vibration data was solely to assist us with engineering the floor system and determine the natural frequency of the building. It was not to continue a legal battle. One thing I'd like to point out, to date there's not been a single DEP violation for any noise code compliance issues. We did our testing and the music is entirely code compliant in the rooms which we were in. Acoustalog's report notes that apparently they could hear in certain rooms. This was not brought to our attention during testing. We would have been more than happy to lower the sound system or identify the penetrations.
Can I interrupt just for a second?
Yes.
Can you tell me what the conditions were in the gym at the time that you were testing?
Yes. The gym was vacant and we had commercial music playing, a track on repeat with 3 songs. I believe it was 20 seconds per song on loop, and we were using that as our source. The sound system is now limited to when you plug an iPod or an iPad mini in. When you turn the volume all the way up on both the iPad and the wall control, the sound system cannot exceed that level. Part of the previous issue was there were 2 just temporary portable speakers, and an instructor on Saturday morning could go in and turn them up as loud as they wanted. So we had installed this sound system, and on July 23rd we wanted to verify its effectiveness.
Just another question with
Yes.
respect to sound. So the gym was vacant. So
Yes.
But normally, the gym has a lot of things going on. There, I don't know how many, you know how many classes there are that are taught in the gym at one time?
I'll let JP confirm the class schedule. What are you doing daily?
You have to come to the,
Yeah.
identify yourself for the record.
Hello, Jarrett Perlmutter.
Oh, what do you know?
Oh, let the record be noted that there is
We're
no
not
relationship.
related.
There's 2 classes going on at a time, 2 exercise-based
2 at a
classes.
time. And what kind of classes are they?
They're fitness-based, functional fitness-based classes.
Which means what?
Which means that we do all types of movements that engage the body in day-to-day natural activities: squatting, jumping, running, rowing, lifting, skipping, crawling under things, over things.
Okay. And during the time that the two classes are going on at the same time?
Yes, ma'am.
So there's music associated with both classes, right?
It would be the same system playing for both classes.
For both classes,
Yes, ma'am.
okay. And then there's an instructor, where's headsets?
No headsets.
No headsets. So there's an instructor
Yes, ma'am.
who's telling people what to do, right?
Exactly.
And they're screaming at people what to do.
It's generally not part of the protocol or the culture of the way that we teach class, but we do get enthusiastic.
Right. And how about the participants in this? Do they get enthusiastic?
They do, but again, it's not generally in the culture to be screaming, hooting, and hollering. It's not one of those types of classes.
Okay. But everyone's supposed to land at the same time, right?
Not necessarily. It's not choreographed in that sense.
It's not choreographed. Okay, but we have people sort of jumping, right?
You would be in like skipping rope.
Skipping rope. Things where there's
yes,
impact. Okay. So now this is a question for Mr. Koch. So then if we just go back to that. So if you're testing in a vacant place,
Yep.
music levels.
Right.
Isn't that a different amount of noise, vibration, whichever thing you're testing, than testing in a place that's got 2 instructors, a classroom filled with, sorry, it was like 20 to 30 students, is that right? 20 to 30 students who are enthusiastic and jumping rope, and an instructor who's not supposed to be shouting but nevertheless is shouting. Isn't that a little bit different in terms of noise?
There's 2 issues at hand. One of them is the commercial music. And we did that during a control test. Remember, the sound system can't go any louder. So whether there's a class full of people or not full of people, the sound system is limited to level X in the gym.
That's the music level.
The music, correct.
But what about the rest of the accumulated level of noise and vibration, et cetera,
Well,
from all those
exactly.
activities?
So the commercial music is code compliant as of now. They've not received a DP violation. We've measured it. Acoustolog's measured it. And nowhere in Acoustolog's report does it note that is out of code compliance.
I've got a question about that, because I think the data that we received, or that I saw, showed a line that was just specifically for music, and it showed occasionally it would pop up above 45 dBs.
Yeah.
So I guess my question is that was that done with engaging the limiter, or was that done without the limiter?
Yes.
And would the limiter keep it at 45 dBs?
Yes, the limiter will keep it at 45. One of the faults of the noise code in New York City is often in New York City in the summer, an apartment with no music on, nobody even in the gym can be above 45 dB. So what happens then? And the code does not have a great provision in it for that call, that instance when it is above 45.
So, but I guess what I'm saying is that if we are keeping this below, we want to keep it below 45 dBs.
Yeah, that wasn't the music.
Well, that's my point. Like, if we turn the music off, some of the measurements were above 45 dB with no music playing.
But I don't think that that's exactly what your data showed. Your data showed that when you were playing the music, and maybe I'm wrong, but I think
I have it right here.
you showed us a sort of a chart, right, of sort of the different types of noise.
Yep.
And then you had separated out the music.
Yep.
And in that separated music chart, you show that, and what I'm hearing is that even with the limiter, you were above 45 dBs. So I guess my question is that do you need to reset your limiter? Or is that, what am I looking at then if you are above what your stated maximum is?
Well, I think
how did you get there?
This chart, correct?
And
this was the last
yes,
report.
but also I think there's another one that didn't really even have an explanation. It was just the simple music simple red line. Mr. Mayor.
Yeah, this was the report that was submitted to the board in our last submission. I think, and David Cott can confirm this, that the music, in no cases does the music go above 45 dBA.
That one.
But the ambient sound, in the neighborhood, or whatever, goes above 45 dBA, as is the case in the gym itself. There's ambient noise in the gym that comes from outside or upstairs or next door, and that sometimes exceeds 45 dBA. But the test for the music itself did not exceed the 45 dBA.
And that's because you put the limiter on.
Correct. And I mean, I just want to point out something as well. We know there was a low frequency sound problem, so you can filter out all that low frequency information. And we have our filter set at 125 hertz and above. That's that information. So it's even more suspects, for example, at 63 hertz, that we would really be seeing a lot of that in the measurements. And then you ask, you know, for example, you see these tiny little blips in it. When we are performing measurements, it records a physical wave file that you can go on your computer and play back. You know, and I'd be happy to play it back for you guys at any point. But you don't hear music in the wave file. For example, like, you know, a footfall somewhere in the building would
account for that.
Exactly. Similarly, in Acoustalogs report from that date, they did not note any noise code. They did not note that it exceeded noise code. So,
okay, I'm sorry, finish your...
Okay, so I think at this point, I mean, the commercial music is solved. We'd be more than happy to, you know, correct me if I'm wrong, JP, but reduce it by another 2 to 3 dB if that's what is required. Similarly, during the testing, apparently it was audible to some people, and there were 6 of us in the room, so if that was in fact true, I mean, we should have been notified and had the chance to go in and hear it and reduce the level.
Let me ask you another question with that. So that was a bunch of people standing around in a room who are sort of awake, and it's 2 o'clock in the afternoon or something like that, right? And so let's just say your sort of acuity levels are a little different at 2 o'clock in the afternoon when you're standing around with other people. It's kind of tense because you've got lawyers and you've got competing acousticians there and so on, as opposed to a person who's lying in bed, who's sound asleep, and who is, you know, very, very aware of pins dropping in the room because that's the way it is when it's really quiet in the morning, right? So isn't there a difference in perception between what happens with a bunch of people standing together at 2 o'clock in the afternoon and a difference in perception with a person who's calm and quiet and alone?
Yeah, I agree.
So if that person could hear it, even that same exact test, they wouldn't be wrong. They would just be alone, calm and quiet and listening, right?
Right, exactly. And, you know, similarly, like at night, a lot of the, you know, the air conditioning levels change. If there's a lot of commercial in the air, people turn it down at night.
Correct.
You know, so in a lot of ways, the city becomes quieter at night. Often in residential buildings, the AC is running, you know, at a higher level at night because you have all the tenants in there. So, you know, the ambient levels without a doubt change, and they're going to shift in the apartment from, you know, time and date.
So then to that point, then the classes started like 6 o'clock, is that something like that?
We don't.
What's the first, sorry, come back.
Jared Promo. We don't begin on classes on that first floor underneath the residence above until 7.
Until 7, okay, 7. So wouldn't it be fair then to say that at the very least you should also have a test that's done at 7, for example?
Yeah.
So that you're catching the full range of ambient noise levels. The air conditioners haven't gotten going, the ambient noise level hasn't increased, all that stuff.
Yeah, we'd be amenable to providing that testing and data.
Okay.
We'd be open to that. A lot of our testing has been in efforts to coordinate all the attorneys and the proper people that all have required to be there, and they don't generally want to be there at 6:30 in the morning, although we are already there, so we are willing to do that.
Sorry, Frank.
And just to reiterate, that is our goal, is we want it to be a happy situation. So if that's what we have to do, and it has to be limited and even lower in the morning, and then it can go up during the day, we're welcome. Absolutely, we'll do that.
So the next part of my question, but you haven't spoken about the weight drop,
The vibration.
so let's talk about that.
That's right. That's the second part of all of this. So I think, as you know, we originally they built this complex floor. They had every reason to believe it would work. They hired, consultants, et cetera, when it was built. So we tried to do kind of a remedial solution with 6-inch foam pads. They're not effective. We finally deemed that after the last testing. They're not nearly as effective as we wanted them to be. We thought we were onto something with it. So I suggested hiring Wilson Eyrig alongside us, who is kind of a global leader in structure-borne noise and vibration, and can really recommend, like structural modifications to change the frequency of a building, etc. Obviously, needless to say, it's a highly specialized field, and very few people do it. So in our preliminary testing, we tested, in the weight drop, we tested the structure, and we were basically at 12.5 hertz, the frequency the second floor is moving at. With that being said, in our calculations of the floor is moving somewhere approximately from 12 to 15 hertz. So they're falling right on top of each other. And we kind of knew this, but now we have data to confirm it. So with that being said, we have to get the frequency of the floor much lower. And the question is, how do you do this? So the ways to do it is, the number one cause of the reason this floor's frequency is so high is that there's entrapped air in the floor. So you drop it, a weight on it, and there's nowhere for all this air to go. So what we're proposing is to change all the springs to a 2-inch deflection spring, which inherently would have a lower frequency, raise the floor another 2 inches to get the air to move underneath it, cut the perimeters back so the air can escape, and then if required, drill holes and physically put like drain covers in them so the air can come out of the middle of the floor if we're still having an entrapped air issue.
So the concrete floor right now is sitting on springs?
Mm-hmm.
Okay, but they're shorter springs.
And the frequency of that floor is exactly the same as the building, basically, which is amplifying it.
I just have a question.
Sure.
When you did the vibration testing, how many people were dropping weights versus how many people actually drop weights at the same time in a class?
Right. Well, this vibration testing, we had, I believe, one person I was upstairs, so
one person.
We had one person dropping, but for this test, this was to learn about why the floor was failing, so we needed a controlled test. We couldn't have 15 people dropping. Right.
So when you actually, I guess, go forward and calibrate, you will do that with many people dropping weights to ensure that any cumulative.
So our next step is this Friday, we are going to set control locations on the structural slab and measure in the gym with a floor that exists as is, with an instrumented hammer. We're then going to cut a part of the floor back, so we have a 20 by 20 test section, and perform these modifications and take the data to ensure it's working.
So you're just going to do it on a test then?
Yes.
And then measure the vibration level from that
But
test?
we're modifying the floor in between the first test and the second test with changing it to a 2-inch spring, raising.
You're modifying just a 20-foot section?
20 by 20.
Right.
Because, for example, there's a bunch of other solutions as well. One of the things we had discussed was lowering the floor, physically unjacking the whole floor to get more mass on the building, which would change the frequency, and then build better localized platforms that were permanently mounted. That would be the second strategy. And then the third strategy would be, we could also use that floor and put air springs under it, which are basically huge. They're like shocks on a truck, and they have air in them, and you can adjust them.
So the question is, though, once you make all the changes, will it make a difference how many people are dropping weights at the same time?
Yes, it will. And step one, we just need to get a controlled test to know that we're going in the right direction.
And so then you'll further refine it?
Absolutely. And if this is working well, we're going to do the whole floor that way and then provide the data to show an improvement.
A question for your baseline. So if you just had one person dropping the weight, and it was 135 and 185 pounds?
Correct.
Right?
Yeah, that's typically what
with pad,
we're using.
not with pad. Doesn't sort of your baseline criteria change if you instead did this during a class where you tested up on the second floor and on other floors?
And to that extent, the other thing that we've learned is when you add 35 people and the barbells, it changes the frequency of the floor system as well. So one of the things we're doing on Friday is we're rerunning the calcs of all the springs. Physically, they're going to scrape the rubber up. We're going to go in, look at every spring, and change them to optimize it and then we can use, for example, I would say 4 people in 20 by 20 is how it would break out in the gym. That would be, I think, an adequate test in the 20 by 20 section.
But in terms of what you were recording on the floor above, right?
Yep.
If you use just your one person, one weight
Right.
test criteria in order to guide you on all of this work, isn't it not really representing the situation? And shouldn't it be full swing class and individual weightlifters and all of that stuff, peak time at the gym, and that's when you're measuring?
Well, I mean, step one, we need to figure out if in fact these floor modifications are gonna work. And that's why we need a control test. Step two is, yes, once we believe it's working and we implement it on the entire floor, then we will do full classroom
But isn't that an
testings.
expensive way to do it? You see if you're going to work this out, you do all that incredibly expensive work, and you go back upstairs and now it's still noisy because you never tested with the gym in full swing.
Well, are you suggesting that we go in and we test now with the gym in full swing
Yeah.
for vibration
Yes.
levels?
At your peakest level,
Okay.
with more, unfortunately, more lawyers coming who have to like take off time from wherever else.
You know, I'm in agreement with it if that's what it requires. I think I'd be more than happy to do that. And to that point, I mean, the last point I had is, I think, unfortunately, with the New York City legislature and building codes in general, there's not a vibration criteria in a lot of them. And I think, you know, obviously the other side is litigating, and there has to be a standard set saying that this is acceptable vibration. Because, for example, if a weight drop's no more than a footfall on the second floor slab, that would be, in my opinion, considered acceptable.
Right.
So I'm proposing that we use the ANSI standard for vibration in buildings.
Well, but the other part of it is, I mean, it really has to do with people who are living on the second floor, and people even on the sixth floor are having experiences with stuff. So I don't actually even think noise code or ANSI code is relevant here,
Okay.
because our test is this having a negative impact on neighborhood character and the ability to continue to operate legitimate uses, right? So if you can't sleep and you're woken up at 5 in the morning, it doesn't really matter what the noise code is. Before the gym came, you were sleeping, and it's a noisy city, and the ambient levels and the trucks rumbling and garbage trucks and all that stuff, people still work through that. But for a continuous sort of assault from below, that's asking people to put up with too much.
You know, I don't think that it's as continuous as, you know, it's kind of maybe led on to believe, and we can determine that in the baseline testing and see how many spikes are happening during the class. You know, I know.
Isn't there some kind of a monitor you can just leave in place in one of the apartments?
Yes, absolutely. Yeah, we can put it in there for 24 hours to record the vibration levels. And that could give us a baseline for vibration acceptability.
Just gonna say something.
Sure.
Come.
Jared Proller. Yeah, I just wanted to touch on that fact real quick, is that the positive thing is, and just not to misunderstand the system, the dropping is not a constant that occurs in every single class every single day, because the programming is developed and devised weeks and months in advance. So like I could tell you exactly what's happening today, and knowing that based on those exercises, there is no barbells and or dropping that would occur, let's say, on a day like today.
Okay.
So
it should be on your worst day.
absolutely, we would make sure of that, as we've done before in just prelim testing.
Okay.
Yes, ma'am.
Yeah, I mean, but to that point, I think, you know, that there has to be, in a way, a standard of sorts. Because, I mean, what happens if it happens 4 times a day, you know, and it's as loud as a footfall? Is that unacceptable? That's happening between 7 a.m. and 10 p.m.? Probably not.
Well, you know what I would say is, once you have the real data, then we know where we are, and as you devise these systems, I'm sure that there are other places where you've got this kind of vibration problem and noise problem, where the systems for floating floors and so on, you know, maybe it's a floating floor on top of a floating floor or something else, right?
Yep.
Once you devise the system, then you'll be able to say kind of what are the potential approaches to this, what your experience has been with those approaches, and then it's a possibility to proceed like that, rather than making the correction first and then finding out it's way too little of a correction. It's a huge expense. And
well, that's why we wanted to do it on the 20 by 20 test, to make sure that we were going in the right direction. And I think the best we can do is essentially a scaled simulation of saying, you know, on average 4 people and 20 by 20 is a good metric, you know, for the gym's floor. And using that as a scale and saying, okay, well, we've made an 90% improvement or 100% improvement. Let's do it to the whole floor now. Unfortunately, this is a complex issue. I don't think you're aware.
Right.
So.
Mr. Angelino mentioned there's another brick on the West Coast that, or in Chicago, that has installed some kind of a system like this?
Yes, that's
right.
correct. I think
Are you aware of that system?
JP consults for a lot of CrossFits that are opening, and they built a 10 by 10 mock-up in a gym in Chicago, and they did weight drop tests, and apparently, I haven't been there, we don't have real data on it.
It's still a mock-up, it's not that it's installed in the gym yet.
JP can comment.
I don't believe it's open yet, the club is open.
Oh, okay.
We have.
Right.
Jared Perlmutter. So what we devised there was smaller sections, which is one of the reasons why we're cutting the test section in this particular location. I'm not an engineer. I don't speak the language as well as they do. I just know by practice what works, and if you can hear it and feel it, it's not good. If you can't hear it and feel it, then that's good. And by devising it in smaller sections and decoupling the floor from having one massive mass has actually assisted the situation and allowed us to not only be on top of a bank and a jeweler, but to be in a mixed-use building with high-end tenants and residents, similar to what we're in.
But this exists throughout the gym now, or
it's under construction?
It's under construction,
yeah,
so it hasn't actually been tested.
It was tested, it passed. The building manager, building owners, bank managers, the whole, we had the whole.
But do you know of another gym that's done this? Where it's installed and operational and everybody's happy, et cetera, et cetera?
Yes. Yeah, yes. I personally consulted on, I think this is my 5th CrossFit gym, Equinoxes and Soul Cycles. So I do a fair amount of
make noise, it just likes me.
vibration though, lots of vibration from bikes, believe it or not. So we have a mock-up in New York City at a facility that's still, I don't really want to go into which facility it is, but I have vibration data that shows that our system there is 100% effective. We represented the one in Jersey City who is pending litigation, and they changed their program, and we built localized platforms 8 by 8, so if you're dropping heavy weights, for example, a lot of the women in the class aren't putting up, you know, the massive weights, and it's been entirely effective. I mean, we haven't had a single complaint from a 10 and above. So,
how high is the 10 and above?
2nd floor, right above it. So similar to this.
Similar construction of building?
Yep.
Okay. Do you have anything else that you wanted before we go to public?
Not at this
time. Are there speakers on this item? Okay. Quite a few. We didn't have a kind of sign in anything?
Do you have any other questions?
Okay, not so far.
Okay, got it.
I'll try to be brief. Jay Ginsberg of Lebanon Glasser. I represent the condominium. One of my colleagues were present yesterday. I just wanted to be sure that Charles Rich's affidavit made its way to the members of the board. We did submit it, and attached was the most recent data from our expert. I wanted to be sure you had that. We did submit it 2 weeks ago. So you're indicating you did, which is fortunate. We're here today of a new report of a new plan to implement. Obviously, we haven't seen any drawings of it, any test results of it, and the board quite accurately raises the issue of real-life conditions in these tests that we've been running at the gym's behest, where one weight is dropped at 135 pounds when the gym is vacant, not being typical. But we've submitted to the board the data we've gathered over several covert tests, which the gym was quite angry about that we didn't tell them we were wiring them up, but we in fact did exactly what the board suggested. We wired up apartments, didn't tell them, and recorded for days on end. We did this 3 or 4 times between December and June, and we have the data sets that show what really goes on when these classes really happen, and multiple people drop weights that exceed 200 pounds in many instances, and the vibrations and noises associated with them. While we, of course, welcome the idea that they're finally developing or trying to develop a solution, remember, they're still operating on a day-by-day basis. They're not offering to stop waking up the whole building every morning while they run their tests, compile their data, and take whatever time they need to resolve this problem. They intend to keep doing exactly what they've been doing for a year while they explore and examine data they could have gotten before they ever opened, and surely could have gotten at any point during the last year. To hear today the experts say, that the padding wasn't as effective as they thought. We've been giving them data sets now since the litigation started back, I think it's late October, early November. So this idea that they didn't know that what they were doing didn't work is just specious. Now, the idea that we might go in now and run tests as the board is suggesting, well, I think is a very good idea. Remember, as long as they know the tests are going on, the instructors will be told not to shout. God knows what they'll tell the class members and what they'll do when they know they're being watched. The real data comes when they don't know they're being watched. And while we're encouraged they're trying something, I don't think even under what we're talking about today, you'll get a true data set because they'll know you're there. Now, I'm going to leave the most recent test results to our expert who's here, and Lord knows this jargon is well above me. But I will say some of our industrious unit owners bothered to research Wilson Ehrig on their own after they saw the submission. And I have it here today. I'll supplement our submission. But as it turns out, most of the places referenced in their report where they profess their expertise, they're all commercial spaces. They're all standalone buildings, malls, commercial spaces. From what we can see, the ones that were pulled by the unit owners, not one of these that Wilson Ehrig has worked on is a residential. And in fact, the one in Minnesota, Minneapolis, there was an article in the newspaper in Minneapolis 2 weeks ago saying that while they were supposed to open in October, they can't because the vibrations were far worse than anyone ever anticipated. They had to delay the opening and invest millions of extra dollars to try to address the vibration problem. I'll submit that to the board later today, but it's not terribly encouraging to hear that the hired gun experts couldn't solve the problem in a purely commercial space on the other side of the country. We also hear that this is going to be a floating floor type system, and the chairman pointed out or asked, wasn't this on concrete? And the answer was yes, but I didn't hear that this is being done on both floors. Remember, the first floor is a floating floor over a slab. The basement is just the slab itself. And we are having, when you drop enough weights right on the concrete slab with the rebar running horizontally, that transmits too. I didn't hear that they're putting that or recommending that they're going to implement a basement solution as well. But when we tested the basement at 185 pounds, you hear it, and you hear it quite a ways up. Finally, we hear that there's going to be testing on Friday, which no one's asked us for access, so I'm assuming that they don't plan on actually taking readings in the units, or they plan on asking me on Thursday for that. But it would have been nice to be invited to that, because we could have gotten our own data sets, wired up the units, and told them what their 20 by 20 cutout sounds like in Unit 2A, 2B, 2C. I don't doubt that their data will be useful, but I expect it would have been far more useful if they knew what was going on upstairs instead of what's purely going on with the gym. And without taking any more of your time, I'll just turn over the floor to Alan Firestein of Acoustalog, who can speak to more of the technical aspects.
Hi, I'll try to be very untechnical. I was listening to what was said before, and I'd like to make a few comments about the overall quality of the plans that are being professed to be in action. You heard the term true vibration data. If you read my latest report, I believe there was no true vibration data taken in my presence during the July 23rd test. Vibration tester was set on a step, for instance, near the outside wall in someone's bedroom. That's not true vibration data. Devices were put on floors in random places. Readings of that type are not useful for the person who is making the tests or the Wilson Ehrig company, which is supposed to analyze that data. And I described that in my report. The fact that you heard multiple times the claim that there was no DEP violation given is basically a whitewash. It's not DEP's expertise to measure impact noise from gyms. They can't sit around and wait for an impact to occur. But the testing that I've done for the last year, without the gym's knowledge, has shown not a sound that sounds like a footstep 4 times a day, but sounds 100 times a day of impacts that actually you can feel and shake, as high as the 6th floor in the building. In the test that we did on July 23rd, we were on the 2nd, 5th, and 6th floors, and you can see clear vibration. And I could feel it too. Now, you also heard the expression that the pads were not effective. On the contrary, the pads are very effective if they're put in the basement. When weights are dropped, and these weights were, all of the tests we've done are 135 to 185 pound weights. Every time a weight was dropped in the basement on a pad, it was incredibly effective. And that's why I said before that if materials were dropped in the basement on a full set of pads where no accidents could occur, I believe there would be no problem for anyone in the building. You were right to mention about the real-world testing, because indeed the test was started at 1:30 on a Wednesday, the July 23rd test, not late at night or 5 o'clock or 6 o'clock in the morning. The article that I just read a few minutes ago stated that in fact the vibration that is delaying the opening of this Mayo Clinic job is coming from weights dropping. So that's the problem that supposedly in the attorneys and the consultants' letters that you received was highlighted as their flagship proof of success. The changing of springs from 1 inch to 2 inch, and here I'm going to get technical, I'll limit to 15 seconds, changes the natural frequency from 3 hertz to 2 hertz. Both of them are well below this 12.5 hertz that you heard mentioned. There shouldn't be that much difference between a 2-inch spring and a 1-inch spring for something that's occurring at 12 hertz. But the main proof is in the pudding, not when you do a 24-hour test by the gym's consultant, because they know it's being done on this Thursday or that Saturday. I've been in court cases before where judges have said it's clearly not appropriate for someone to say, okay, jump, and the person jumps, and then they're being measured because they know they're being measured. If you want to look it up, there's a case called Pilot Recording Studios versus Sutton Gymnastics, in which they clearly, it's on my website, but you can also look it up. It was in Supreme Court, and the judge unfortunately had to close down the gym. It was a kids' gym. The last thing I want to tell you is this. No one has mentioned the ceiling in this situation today. I've mentioned it repeatedly. When you drop a weight on the floor, it makes vibration that goes up the structure through the walls and through the columns. I don't know what percentage is going through the columns, what percentage is going through the walls, but I do know that some sound is being created by the vibration of the floor into the air. And there's no drop ceiling in this place. And for a year, we've been asking to put this drop ceiling on, not just for music, but for the voices, which you correctly noted are instructors yelling, but also for the weights, and no one's really thought about that. There's a loud sound, it can come up through the ceiling, and if you don't have any protection for it, and they didn't right from the beginning, then you're allowing the sound to bypass, at least into the 2nd floor, any kind of vibration materials that you put down on the floor. But if, I said this before, if you put full padding in the basement, they can drop weights as much as they want. But remember, we've only tested from 135 to 185. I had my assistant call up the brick gym in July, and he spoke to a fellow and asked him what weights that they use. And he said, well, we use pretty heavy weights. And so my assistant said, use like 300, 350 pounds. And the expression was, oh, easily. Oh, easily. So we've tested, in most cases, with one person dropping one weight from 135 to 185, and that's my statements of today.
I'm looking at your report, but I actually, so these reports that say 155 pounds on platforms with rubber, for example, so that means you were doing your own testing simultaneous with Criterion doing their testing? Is that what you're saying? So you're referring, so everybody knew now we're going to do 155 with rubber, and so you made a note of that, and these are your test results?
Yes.
Right. And so why are they so different from the test results that are, what kind of equipment did you use that was so different from what they used? I mean, I don't understand how the equipment can be reading so differently for the same exact test.
Well, you know, I've been in situations where judges have actually come and heard with their own ears and felt with their own feet the vibration, and you're invited to do that, I'm sure.
No, just curious about the testing method.
I think she's referring to the testing method is...
I think she's referring to the hertz level difference.
Well, for instance, I'm just looking, for instance, you have the dBs, your report refers to dBs and which one is at which hertz level, right?
Yes.
And, you know, the chart is kind of way up here, whereas the chart from Criterion is sort of traveling along here. It's how come the equipment is reading so
I understand your
differently?
confusion. You're right. The chart in the Criterion report shows music, not vibration.
Okay.
Despite the fact that they were dropping weights on the floor on July 23rd, which was my main concern. It's always been my main concern, because I know if they put in a drop ceiling and get those speakers off the ceiling and get the springs adjusted right and put the limiter on properly and don't use an amplifier where you can turn up the bass on the front of the amplifier despite what the limiter is doing and all the other criticisms which you saw in my report, I was concerned about the weights. So I measured vibration data, and you're looking at the sound in the air from the weight drops, whereas the Criterion data shows the sound in the air from music. And I didn't
we don't
measure
have
the
an
music.
apple-to-apple comparison between the two experts?
No, I didn't measure the music. I just walked into other rooms while they were randomly testing in different rooms, and I heard music coming up through the floor in the bathroom of 2B. I heard music coming up through the floor of the bathroom in 2A. I didn't mention it. I was just there to observe. I wanted to see whether they were being thorough, and I don't think they were being thorough.
Okay. Any other questions? Thank you.
I know a few of the unit owners did want to...
Please restate your name again?
Sorry, Jay Ginsburg again of Lebanon Glass Hair. I know a few of the unit owners came today and wanted a chance to address the board on things that have happened since the last time they were here. Anthony, you want to...
Sure.
Please state your name for the record. You'll have 3 minutes.
Good morning, my name is Anthony Yu. I live in apartment 2B in the condominium. I just wanted to make one point and reiterate one that was expressed in July when I spoke. One is, this is not an infrequent occurrence. On fully 71% of days that I'm home, I notice vibrations. And while, as was previously mentioned, classes may start on the ground floor at 7 a.m. In fact, they start on the basement level at 5:45. I go to Soul Cycle occasionally in the morning, and I'm awoken, despite trying to get myself up for an early class. That aside, though, my apartment has been accessed at least 9 times that I can remember, and that my emails just mentioned, for testing and for observations and whatever. And that's fine. I work a lot. I'm not home. But I guess I worry now there's a lack of good faith that when people go in them, that they're actually trying to solve a problem. I know that these can be iterative processes, but really 9 times and no observed improvement in terms of frequency or intensity, to me is baffling. And I just, the fact that in the stated remarks from Brick that the consultant or whoever who's worked on the Mayo Clinic and 3 equinoxes in Florida, South Florida, it's like me saying, well, I'm going to do testing at Walmart or something. Well, I don't live in a Walmart. And so that's great that they've had success there, but that's not my lived experience. So I just, wondering if they're hiring a group that has the experience, capabilities to solve the problem. And that's great if they do, but I just wonder if they're just kind of buying time again. I just hope that I'm not standing here again in a year and have 19 requests to access my apartment. Thank you very much.
Jay Ginsburg again, introducing Charles Rich.
Charles Rich, excuse me, I'm the Vice President of the Condo Board of Managers. My comments will be very brief. This process started in a litigation, but also started with a meeting before the Chelsea Land Use Committee in October of last year, almost a year ago. After the October meeting, there was then a November meeting, there was a recommendation, and this has now gone into, it's over a year's anniversary of the whole process. As Jay mentioned, I appreciate the effort, but frankly, there's an old saying, fool me once, shame on you, fool me twice, shame on me. This has fooled me 12 times, 13 times, 14 times. And I live on the 5th floor, so I'm not as directly impacted, but I've seen the efforts, and frankly, one of the things that was not mentioned today is certainly not on the most critical level, but we've been asking for months and months and months to stop having running exercises outside the class. We have a very narrow sidewalk. People stream out in opposite directions. It's a minor miracle that no one's been injured up to this point. And it's the simplest possible thing. I appreciate the desire to go run outside and get your testosterone and androgen going, but that's not what it's about. It's about being a good neighbor. And fundamentally, I have to say, I've given this so many times, Brick is not a good neighbor, and let's call a spade a spade. I don't know why JP can't say it. They're a CrossFit gym. And I have to say at this point, I don't know if fundamentally a CrossFit gym within a narrow residential condominium use is the appropriate use of that space. I'm not saying all gyms. I'm saying a CrossFit gym. Thank you.
Jay Ginsburg again, introducing Greg Loudermilk.
Hi, I'm Greg Loudermilk. I would like to talk a little bit about my integrity. I work across the street for the Department of Homeland Security. I have a top secret security clearance. My job is to protect everybody here in the city and the nation. So when you get vetted for a top secret security clearance, I mean, they check everything about me. So my integrity is beyond reproach. So when I say these things, it's with conviction that I say it, and I'm very honest when I speak. I'm the only one in this room that has done all the brick classes, and I live in the building. So I know what the impact is. I've seen it, I've heard it, I've lived it. I no longer go to the gym anymore because it was a conflict of interest. They let me go for free for 90 days, but they're like, how come you're not coming back? Because I said, because we're taking you guys to court. We also have a court case going on with this. I tried to share the noise levels with the club manager. His name is Will. He's a really good guy. I like JP, and where's Jared? I like these guys. But the thing is, they're impacting our lives. I mean, we're talking apartments that are worth millions of dollars. The cheapest one is like $1.5 million, going all the way up to like $10 million in the building. So it's worth a lot. Their investment, if they say, hey, we spend $1 million, that's nothing. That's absolutely nothing compared to what the building's worth. So I shared with Will, hey, this is what's going on. I said, I'm hearing noise at 5:30. I'm hearing this, I'm hearing this. Oh, I'm on it, Greg, I'm on it, Greg. And then 11:30 on a Saturday, I said, man, it's out of control. It's driving me nuts at 11:30 because I have to work at night. I work in a command center. I said, I can't go to sleep. Should I have to put in earplugs to live in my house? A multi-million-dollar apartment, should I have to put in earplugs? I don't think I should. So I called him, and I sent him an email. He replied back. He goes, I checked our cameras. I don't know where their cameras are at, where their cameras are at, but he said nobody was in the gym. I said, I challenge you, Will, to give me free access to your gym, and when I hear something, I'll go in there and I'll videotape it with my iPhone and I will send it to you. He never reciprocated back. So I felt like I was called a liar that day, and that's when I quit sending him emails. JP had said today that there's no noise before 8 o'clock. There's no loud classes before 8 o'clock, or there's nothing?
7 o'clock.
Yeah, 7. There is 4 CrossFit classes before 8 o'clock. There's 13 CrossFit classes scheduled today. CrossFit is dropping weights and loud music. I took the classes, I did it. I quit doing because we were lifting such heavy weight and I'm getting to be old that I was hurting myself. But it's dropping loud, heavy weights. And for me, it was about 135 pounds. There are some pretty big guys in there that can do a couple 100 pounds. I never saw anybody do 300. That's a stretch. But a couple 100 pounds is a lot to drop. And we were doing it the way the racks are set up. There'd be at least 8 people at once. They would do it, and then there's a cycle where they're going around jumping on like boxes this big, up and down. So you're getting all this noise all the time. So Is my time up?
Yeah, I don't know.
I'm allowed to continue?
Just to quickly close.
I guess the only thing, I just hope that you guys as a board have the courage today to shut them down until they become compliant. If you don't shut them down, there's going to be no accountability. I mean, the music, I hear the music every day at 7 o'clock. We could go to their schedule, see who it is that's cranking the music, because I can hear the voice too. I could probably tell you the name, but I just hope that you have the courage to shut them down until, like I said, they become compliant. So, thank you.
Next speaker.
Jay Ginsburg again, just introducing Susan Gomes.
Susan Gomes, and I live in 2A, so I'm right above the gym. I'm not going to belabor it. You've heard pretty much from everybody, and especially from our side, everything that we've been going through. It's been going on for 14 months. I am home much during the day, so I have been around for at least 4 or 5 of the tests that have come on in our apartment. They are not realistic tests. I think I wrote that in my affidavit. There's one person, I'm not going to belabor it. It's not accurate. It's not an accurate assessment of what we lived through. We are hearing it in the morning. We hear it at night. My kids have trouble doing their homework because they need to do it on the computer in the room where the vibration is the worst. And we are woken up by it. I can hear it through the pillows in my bed. I don't want to live this way. I shouldn't have to live this way. I don't want to have to make accommodations to them. We have been asked repeatedly, and I have been fairly consistent about reporting by email whenever I hear something. At some point at the last community board meeting, one of our condominium owners had gotten tired of sending stuff in. And when he complained he kept hearing it, and he said, oh, well, we haven't heard from you. Now it's our burden to tell them, and there's a fatigue factor of trying to remember, oh, I heard it again, I have to report it again. We are done. We are so tired, and I don't think there's been good faith in them trying to fix it. I just don't. So I think.
We're done.
I understand that Mr. Ginsburg is a litigator, and I'm not a litigator, so I don't know how these things work. A report was submitted to the board, and even though a prior one was given to us, the report with acoustologs information wasn't given to us, even though the channels of communication have been open. And as you heard from them, they did their own testing without involving us. The only reason we were able to do the testing is after they began the litigation, the court mandated testing be done, and they to give us access for the testing. So make no mistake about it, from the beginning, their whole purpose has been to get Rick out, because they're not in privity, as the vice chair said in the review session on July 14th. There's no privity between the two. They own the condominium upstairs, and the condominium is owned by a different owner, which is Rick's landlord. So they're not playing by the same rules. They want to use litigation tricks in order to get, we've been very open, and all of our tests have had everybody there. I was there the day of the music test. I saw Alan Firestein go into the bathroom. I assumed it was for normal purposes, but instead, apparently, he was going in to test and not to tell everybody so that we couldn't cure the problem. I thought the purpose was to cure. From the beginning, we've been trying to cure, they've been trying to get us out.
Can I just ask you a question about that? I mean, they submitted this affidavit with the test results
We
to
haven't
the
seen it.
board,
But, I mean, sorry, in my old job, before I came to a hearing, I would check whether there was opposition. Didn't you call the BSA and ask whether there was anything filed with respect to this? I mean, that's pretty normal to do.
Yeah, we did check. I don't know at what point, but we didn't receive it.
I'm sorry, if I can.
I'm sorry, no, sorry. He has the floor.
Sure.
I respect the expertise of the chair, but previously something was sent directly to us. So I assumed that if something was going to be sent to the board, it would be again sent directly to us.
So it would be a great idea then if you could get a copy of these submissions and you could respond to them.
We'd like to look at it. We'd also like to examine Mr. Firestein's expertise, his educational background. to see what makes him an expert. Because you've heard Wilson Eyring, which I know the board members know as a respected consultant on vibration, one of the preeminent ones in the country. You've heard people try to pick apart a listing of some of the projects they've been working on. They don't know whether Wilson Eyring has been brought in to cure a problem that was pre-existing, but yet they've tried to defame Wilson Eyring by criticizing them on certain projects and I understand they're trying to distinguish it from this project, but I don't think the way to distinguish it is by attacking Wilson Eyring, because I think their reputation speaks for itself. They're an acoustical vibration expert, and if they want to put in testimony to show they're not an expert, they should do that directly. A couple of other things. When it was mentioned about apartment 2B, when we went into apartment 2B on July 23rd, the entire apartment was under construction. I don't know whether it's completed by now, but it was entirely under construction. Yet you received a letter describing details about as if the apartment is occupied right now. I don't know whether it is, but it was under construction.
So you're saying there isn't any noise in the apartment?
I'm saying nobody's living there as far on July 23rd. It was a construction site, and if it's a typical New York construction site, I don't believe the construction has been completed to date. Because we heard lack of good faith on our part, but we want to point out there's been a lack of good faith continuously on the other side, but we're not here in opposition to them. As I mentioned before, we're here to do a win-win situation. One point with Al Farsten, he mentioned about the cellar. Every drop in the cellar, everybody who uses weight in the cellar uses pads. So nothing is not dropped on pads, as Mr. Firestein recommends.
No, I think he was talking about the 6-inch pad test. That was, I think, obviously it's not.
Well, it wasn't a test. We weren't testing. He took measurements.
No, but the test that Criterion did, or whichever company did, was on 6-inch pads. They lifted the weights and dropped them on pads, or dropped them on the floor, right? I think you're referring to the 6-inch pad, which was hoped to be one of the solutions, and your consultant says it's actually not a solution, but maybe there's a way of...
It's not a permanent.
Not a permanent
Yeah,
solution.
that was the
Yeah. But again, we're aiming towards a permanent solution here. But we have a different interest in solving the problem. We want to make it successful, as it has been in the neighborhood. There's over 700 members from the Chelsea community, and as you heard, even from the building itself until they were in a litigation and people from the building could no longer join BRIC.
Okay, I have a bunch of questions, so I'm sure everybody has questions. So the first is, now I'm looking at the Criterion report, and I see that it is just noise levels. I thought there were levels, aren't there levels that were tested with the drops?
Please state your name for the record.
David Koch. We were testing that day for vibration to determine the frequency of the building.
So what was the point of dropping? You were testing the drops for vibration?
Yes, to determine the frequency to figure out how to solve this floor issue.
Okay. So somewhere in here there are test results for the drops.
I did not present them that day. The airborne, because once again, it was sheerly to determine how we were going to fix this floor. There's previous reports I've done. I can give you the dates of the previous weight drop tests. When I thought you had submitted. When we had left the BSA last time, the goal was the 23rd testing was to test for commercial music, make final sound system adjustments, and confirm that the limiters were set properly.
Okay.
And then we performed secondarily was weight drop test for our own engineering purposes.
But you didn't present that material to us?
I have presented the weight drop test before that we've done in a similar manner. I have the
but
data.
You did not present weight drops in this past submission, right?
No,
you just
correct.
gave us the noise transmission.
Correct. Sound transmission.
Sound transmission, excuse me.
Yeah, I can pull all that data.
Okay, please.
Okay.
So so this is a whole bunch of questions. So the representative for the condo suggested a few things, and I'm curious why those things aren't being considered, or maybe they are. For instance, the drop ceiling, a hung ceiling, why wouldn't that be an acceptable, let's say, measure? No, I'm not saying a solution, but a measure.
I mean, we're going in order of operations at this point. I agree with Alan that, or sorry, Mr. Firestein, that in fact there could be an issue of dropping a weight on the floor and airborne to structure-borne noise transmission occurring. I'm not disputing that at all. With that being said, I think step one is we wanted to solve the floor issue. You guys can attest whether we want to put this in. We've discussed this in past about installing the ceiling. So, I mean, I guess we can further discuss that and come back to you.
So they've listed a bunch of things.
Okay.
A drop ceiling, actually putting padding right now in the cellar, arguing that the longer springs actually aren't going to make that much of a difference because you're only changing it by a hertz. Take the speakers off the ceiling. I don't know if they're still in the ceiling. And then there's a separate issue about the running exercises. What if you were to just implement sort of all of these things right now? I mean, those are easy things where you don't have to remove your slab and all that sort of stuff, right?
Yes, ma'am. Jarrett Perlmutter. So just to touch on all of those, we did fix the music situation. We did direct the speakers down. We did put them on spring limiters. We did put the volume controls on limiters in a locked area that cannot be controlled. You need to go be a professional computer programmer and have the key to get in there to change anything where it's set. If they still believe that it's too loud earlier than 7 a.m., just touching on what Greg, Mr. Latimer said, you know, reputation is everything to me as well. If you did any research on me on any of my locations, I don't have one mark of ever having an issue with any landlord or tenant. I currently have 7 locations with 4 others under construction. This has been an issue. So good faith, being questioned on that, it hits me more to the heart than it does anything else, because we only want this to be a great place for everybody to enjoy in the community and everything around. That's why I do this day in and day out for a living. And I want to make note that, so on that, everything we are doing, and Jared and I are doing as the owners of the location, is based on professional recommendation. It's not a good faith or a bad faith thing. We're spending money hand over fist to try to resolve issues, not to buy time. That's not our goal. So when we were told of a new sound system, I know numbers don't mean anything here, but that was, you know, $25,000. Let's do it. We've got to do this. We've got to solve it. We did it. The speakers, all floors, everything was controlled, locked up. That was asked of us, and we did it. With the ceiling, we're starting with ceiling penetrations. It's the piping in the bathrooms that they said that they can hear it through. We've already got the engineering plans and the designs and the contractor ready to go to begin on step 1, which is filling in the protrusions in the ceiling, penetrations in the ceiling, and go there. Then they would do a secondary test if that didn't work. We already have the engineered plans ready to pull permits if needed to do a drop ceiling in this situation. So this is not stuff that we've looked over. We're not trying to buy time. It's all in the hopper, ready to do. But and again, I'm not the engineer professional, but from what we've gathered is everything has to be done methodically, or you could get to the end of the road and realize that 20 of the steps you did on the way there were either unnecessary or affected your final situation. And so the last thing I wanted to talk about was that on the flooring, you'd ask, you know, why haven't we tested the drops in the actual apartments? And so I'll speak from very layman's terms. The floor itself is like a living organism, and they have to test in a localized area to find out what that organism is doing, how it's producing energy and vibration. Until they get that, it's unnecessary to go upstairs to hear what it sounds like. Like, you can go there and hear it and feel it, but that's not the information that was needed to devise the final plan of how we're re-engineering, cutting, slicing, and developing.
Right, that's to isolate the floor.
Yes, ma'am.
But that's assuming that that's the only source of the noise, is that the bounce of the floor that pushes the air up, as opposed to other born noise sources like the ceiling, for
right,
example.
and we're attacking all of it. It's all, none of it's been overlooked.
So how much time will it take to do this?
So I kind of outlined a schedule with all the appropriate people, like the spring manufacturers, etc. On Friday we have our internal testing, which is just to determine the frequency of the floor systems, and we're having a meeting that afternoon, which will I believe it's about 3 weeks. We could get the springs and then a 20 by 20 test section built and
Okay, but that's just the 20 by 20 section, and that's 3 weeks, right?
and hoping that we've made a significant improvement.
And then what if, let's just say, it doesn't work?
So second step after the springs is to go into an airbag system. And then after the airbag system is to test, which we know would work. It requires a lot of re-engineering and building permits, and disruption to everybody as it's under construction would be to lower the floor and cut 4-foot channels in a 4-inch slab all the way down the line and then insert the padding in that direction. So these are all things that's why we're starting with the 20-foot section. From 20 foot we go to the springs, we go to the airbag system. After airbag we go to code red, which is slam floor.
As you're talking about this, if that one doesn't work, then you need to prepare, and then that's 3-4 months or 5 months or something to actually implement the airbags. And each time for all that time period, you're still having this nuisance that's caused against the neighbors, right? So my question is, for instance, if padding in the cellar, however that works, like what is on the cellar floor right now?
It's a 1-inch rubber top surface, and then we use a 6-inch foam padding for any weight dropping.
Is it a permanent 6-inch padding, or it's a troweling?
It's a portable.
It's portable, so that when you have students who are doing the drops, each person sits on a pad,
they have their own station.
And are people actually hitting the pad, or
Yes,
those
ma'am.
are only the ones who are really good, they hit the pad?
No, ma'am. They're hitting the pad.
Okay, so then according to that, then you wouldn't be, according to what
Fire
Street, right, said. Then there shouldn't be noise from the basement because you're actually dropping on pads, but apparently there's noise from the basement?
No, ma'am. We've from what I gathered, we were all in agreement that the basement really had become a non-factor at this point, other than trying to make sure that it also wasn't a music issue that was escaping out of any windows. So I think really most of the focus has been the main floor, and that's where our energy has been spent.
Okay, so but to just go back to try to isolate this, what's wrong with the drop ceiling solution, which seems to me a lot easier than lifting a concrete slab and doing all these tests and all this stuff?
You're still going to have bothersome vibration with the floor right now.
Right, but the floor seems like it's a potential 5-month out solution, whereas opposed to a drop ceiling where you have you don't have any insulation. It's probably the slab that we're looking at.
There is a fireproof insulation.
Negligible in the world of it.
Right,
Sound isolation.
right. So that's why. So it's essentially direct impact
applied,
on the slab. Oh, it's applied. It's sprayed on.
Currently, there's a spray on.
Oh, it's sprayed on. So you have absolutely no sound insulation on your ceiling.
And right now, there are a lot of penetrations. I've prepared all the drawings already for the ceiling.
So what if, in the effort of actually doing something right now, as opposed to testing and then thinking about doing and all that stuff, you actually closed up the holes in the ceiling and dropped a ceiling that's insulated properly with acoustical insulation, and continued then to work on your floor solution? Because I understand that's a much bigger study. What about that?
It's a viable solution. We want to make sure that if we do, to be transparent on that, to make sure that the drop ceiling would work is also the concern of everything else, which is by first doing the penetrations, we would know how much sound is still escaping, because we could go through the process of laying in this drop ceiling.
But it doesn't really take a rocket scientist to know that if you've got a slab that is not insulated, that there's born noise through the slab, right? I mean, if you have people playing upstairs and the kid is rolling a ball and there's no carpeting, we hear the transmission, right?
Yes, ma'am. I think the concern is that based on the testing that we did, the airborne sound was based on city regulations wasn't an issue. That's what we were told by professionals.
Right. Except that the airborne sound being music, right?
Right.
Music vibration versus...
Exactly.
But what I understand from the testimony is that the residents can also hear the instructors shouting commands. So that's airborne, right? And some of the music must be airborne, or you wouldn't be able to hear what's on.
Right, and I guess would possibly saying something that left and right probably wouldn't want me saying would be that we're just being told that if it's under the legal limit, then you're okay. So I understand that maybe they're hearing it, but if it's like...
Right, but so you're trying to stay out of a lawsuit, right?
Out of
yes,
trouble.
maybe it's under a legal limit, but the fact is if I can sing along with the music on the second floor, it doesn't really matter, right?
From what we've gathered through the testings, you weren't able to do that. I was present as well. And unless you had your ear, if you were sleeping on the floor...
Well, but that's part of it. The music starts at whatever time, 6 o'clock or whatever time, so that's when you're more susceptible to being able to sing along with the music. Right?
So if I could offer this, is maybe what we do is set a protocol, work with the building, and let them be honest with us in the sense that we will reduce down the level of music prior to a certain hour and then raise it back up. And if they tell us still at that point it's a continued issue, and this isn't something that needs to drag on for weeks, this could take a day. Right. Somebody calling down, you know, we can do a test with someone in one of the apartments who would be willing to call us at 5:45 in the morning, and we can do a quick test, you know.
Well, let me just ask you, would you also be willing to do that in the interim while you're solving the vibration, to change the nature of your classes so that they are not vibration producers during the time when it's necessary to come up with a solution?
Absolutely. We have been doing our best to do that all along. It's just been difficult to communicate on a non-battling, let's email 7 attorneys just so we can like say one word to each other level when I'm just a guy who wants to chat it out.
But I mean, if all of the heavyweights were only dropped in the cellar on pads,
right,
maybe that's good. I'm not sure if that's good.
That's where we've done it. That's where we've moved it all.
And then what if you kind of either eliminated weight drops from your classes, or you, significantly modified your classes during this time when you're working this out? That might motivate you to work this out really fast.
Yes, ma'am.
That's doable? So we need to hear what it would be that you propose to do, to basically eliminate the nuisance while you're working this out.
We can do that.
Okay. Okay. Anybody else have any?
If I could have 1 more minute of board's time?
Is that okay? Yes. Thank you.
Jay Ginsberg again. I was on vacation in Canada when we made our submission, but when I did, I checked with my paralegal and she assured me she served everyone. The copy didn't reach council. My heartfelt apologies. I'll make sure you get it today. But I did follow up to make sure that she served them, and she informed me that she did. So if you didn't get it, I'm puzzled. Maybe she sent it to Mr. Kaplan, who's co-counsel, and omitted your name from the service. I don't know. I'll check immediately.
Thank you.
As far as Mr. Firestein's expertise, one need only go to his website. I did, and he lists dozens and dozens of cases where he's testified as an expert witness. I mean, his resume is there, and it's pages and pages long. He testified in front of the city council when they adopted the noise resolutions. He was consulted when the regs were actually drawn, so it's hard to imagine somebody who's more well-credentialed, and it's all public information. I was a little troubled by what we just heard, because the commissioner quite accurately finally pressed him to do something real and not something terribly expensive that could be done relatively quickly, a drop ceiling. But like everything else we keep hearing, it's always, no, let's run more tests and then look at the tests, and then maybe we'll consider some other options, and then we'll run some more tests. We've been hearing this for a year. So when finally pressed, put in a drop ceiling, you couldn't get a yes. Look at we. We've been telling them to only drop weights in the basement, eliminate weight drops from the first floor. So, well, at least from the video cameras I've seen, it hasn't stopped, but I don't get the tapes on a day-by-day basis. I only get them under very limited circumstance. To say that now it's going to be the unit owner's obligation that every time they hear something, mind you, we have been sending them reports as we get them. I, every day or every other day, mail Jeff Kaplan, who's counsel on the litigation, the latest complaints that I get from the unit owners. But to make that the solution, that every time we hear an instructor, we should tell you so you can continue to modulate your test results because you haven't put in a drop ceiling, it's really shifting the burden. I mean, and to say that they've been doing this all along and this is part of their good faith efforts, it's been a year, and you're still seeing the data sets that you're seeing. A drop ceiling could have been put in over a span of less than a week, a year ago. It could have been put in when the litigation started. It could have been when we brought the issue up in front of the community board. It could have been brought in since the last time we were here. But still, we don't get any commitment to do it. Instead, we get, give us 4 months to do this, and then we'll see what the results are. And we're bearing the burden. I mean, the unit owners are the people who are suffering. They cash the checks, they have the members, they get to keep operating. Yes, there's a violation, but that doesn't seem to bother them. And we have to live with it.
Okay. So this is my take on this. So the first thing is we really, as this continues, right, and this battle of experts and so on, which is kind of, frankly, a waste of time, right? The fact is that there's nuisance. The nuisance isn't going to be judged just by whether it's 45 dBA. The fact is there's nuisance in the perception of the neighbors. They wouldn't take the trouble to come here if they weren't actually experiencing this, right? And the nuisance actually needs to be dealt with before this permit can be approved, right? So, so my feeling about this is you really do need to come up with a plan that we hear very soon for what measures you're going to take to eliminate the nuisance during the period prior to us being able to grant, and what you're going to be doing to make those changes to the physical changes to the space, which may or may not include a drop ceiling, but I don't understand. The reason we have drop ceilings is for all kinds of acoustical reasons, including the space that we have right here, right? So I'm not understanding the resistance to a drop ceiling. Maybe it's not pretty. There are pretty drop ceilings. So there are plenty. And so I understand you need to fill in the holes. That takes a weekend with a bunch of guys, right? You don't need to do a study about holes. You wander around, you look at the holes, and you fill them. And drop ceiling, it's called, you know, some quick plans, and you get it going, and you can have that installed in a few weeks, really, if you just got it together. So I'm not understanding at all why there's pushback on that. And then the next is, assuming that that's not enough, because I do understand there's vibration based and it's not going to be cured by the drop ceiling, then in the meantime, while you're figuring out the isolation system, which I do understand requires testing, you can't just jump into one, it might not work, right? That you need to modify the behavior of the gym in order to not be a nuisance. And if what that takes is having your guys install monitoring equipment that is staying there with a reader that you can have a printout off-site so that you don't have to disturb the neighbors all the time, then that's really what needs to be done. Otherwise, I just don't see how we can make the finding that you're not having a negative impact on the ability to continue to operate conforming uses more in the neighborhood, not to mention upstairs.
If I might have a minute to discuss?
Yeah, sure.
The client is in agreement with the suggestions of the chair.
Okay, so how much time do we need? I hope it's not a lot, to come up with the response of what you're actually going to do?
Well, I think that the drop ceiling, from what I understand, takes at least a month
Okay, great.
to construct, plus permits. So whatever that period is. Plus the other suggestions for behavioral modifications can be implemented rather quickly.
Okay.
So, and nevertheless, I think that the club will continue with the vibration efforts that they described, because they believe that apart from airborne noise, there's a vibration situation, that the pads, while they take care of most of it, do not take care of all of it necessarily.
Right.
Okay? So if you're asking me for a time, I would think that a reasonable request is 2 months.
2 months to install, to complete the installation of the ceiling. What I'm talking about is a written submission, so
to get permits,
an affidavit essentially from your client that says, I will do these things, and I will do them within X time period.
That we could do within 2 weeks.
Okay, great. So that's a submission on the Was that the 30th?
30th of September.
Of September.
Right?
What are we up to? Yeah, 8, 1,
With a schedule of construction on the site.
We should have it by then.
And, yeah, with a schedule of construction, which means, if I understand correctly, you already have drawings prepared for the drop ceiling. So the submissions for DOB approval, I'm not even sure what kind of permits you need for that, because it's not non-structural.
Do an alt-2, you can do it as a, you know,
self-cert.
Self-cert.
We'll have to alter some of the electrical.
Okay.
Okay. Okay, because we want to know that you're underway with this ceiling within 2 weeks, really. There's no reason why you shouldn't be able to get underway, have the equipment on, have the materials online.
One thing to note, the ceiling we're discussing is...
You must have definitely stepped in front of
Oh, sorry.
the microphone, so identify it. Because we do a transcript.
Yes. Yeah. The estimate for the cost of the ceiling is several $100,000. They're willing to undertake that.
Well, it's the cost of doing business in a crazy
expensive city.
Yeah, it's an expensive city, and the next time, find a nice manufacturing building to have your CrossFit gym.
Welcome to New York.
Well noted.
It used to be. It was once.
Yeah, well, that's what happened.
Just 70 years too late.
Sorry, to respond to their submission? Sure, well,
We'll accept that if it's in the spirit of cooperation.
right, so
not
the,
just
so
in
the thing is, this isn't the litigation department, this is the Board of Standards and Appeals, and what we're trying to do is see whether they should be getting a permit for this use, right?
We just want our experts to look at their,
Okay.
what they're preparing
Right,
to file.
so,
with
but
the
I'm
DOB
not
to make sure.
interested in a battle of experts. I'm assuming both experts are qualified, or you wouldn't have gone to all that money to hire them. But the report should be responsive, and with the goal of trying to find a solution. So we've already talked about a hung ceiling, which is what you had said you wanted to see, and they're willing to spend significant money on, and I think that's a sign of good faith, big sign of good faith. And especially because we are going to make sure that we see permits out, we see construction work done, and that is going to occur before we are able to vote on this item, okay? Okay, so the submission date on the 23rd, no, what did I say, the 30th?
30th.
The 30th, and the response on the 7th?
That would be fine.
And then I'm not sure if we're scheduled for another hearing. Well, I guess we scheduled for a hearing to find out where things are. Okay, so the hearing on the 14th.
There's no hearing on the 14th.
Oh, sorry, the 21st. But by the 21st, by the way, that's a long time from now, a lot better have been done on that ceiling. Okay, we want to see photographs of your progress. Okay?
Thank you.
Thank you.
You want next time?
Oh, we were going to take a break? 5-minute break, please? Okay, thanks. Breathing break. Breathing breath.
We're on the camera.
Yeah, be careful.
Okay. I like the whole time you're so silent.
Right,